card में यहाँ लिख दो, the amount shall be deposited within a period of 1 week. Full stop, compliance affidavit will be filed. Post this matter next month, next Monday.
You just submit now. Just
You are in insolvency, we understand that.
no, I'm not talking.
So we will send you as son-in-law of the state, we will send you jail, free roti and.
Insolvency, Lord. Lordship has frozen their other accounts also.
No,
Everything will remain free, interim direction to continue.
yes.
Then where will we pay from? That's the problem.
You tell us, make a statement that you are willing.
Yes,
No, my lord,
I'm making a statement on instructions that we will give a complete.
my lords, they have accounts in Delhi because they have registered companies in Delhi. My lord says only using the accounts in Punjab and Haryana. They have accounts in Delhi. They have innumerous accounts in Delhi in their registered offices in Barakamba Road,
You give us the.
Delhi.
details.
I'll give a lordship,
No. You give us your bank accounts and the amount lying there.
Give me, lordship, give me 2 days time. I'll give a complete workable plan.
We will
No,
not.
no.
There is no question of it. Mr. Balla, please don't irritate us by saying workable plan.
No.
What is the workable plan? They have made everything unworkable on the earth.
I'm saying I'm not.
We are not going to consider any plan. Our order is very clear. If you can, we give the bank account along with the amount, we will direct do defreeze and transfer that amount.
Give me 2 days, I'll bring all that.
No, no.
Lordship, just adjourn it.
Lord, if I can
They have,
just
look, the
say one thing,
Delhi account is there.
one fact
They have
needs to be
account in
placed.
Maharashtra. They have an account in Delhi. They have accounts all over.
They must
Delhi is
have
a
any
registered
account
office.
exchange. They need
They have-
so many bank account to dupe the people and to siphon their money here and there.
Lord,
My lord, I would have thought they would have brought the demand drafts today.
Can I make one request, Feroz? Can I make one request, Feroz? I represent independent directors, Feroz, who have, one is a lady in the IIT Delhi, Feroz, she has no share in the company. And two are the CA and the CS. So they are the 3 persons who not participate.
No. They are the main directors of HESNA. But this lady is a director of HESNA. Yes.
Independent directors, out of 3, one is a PhD from IIT Delhi, one is a CA, one is CS. They are not concerned with the affairs of the company from day one. They only have taken sitting fee, nothing.
How are we concerned whether they are concerned or not? It is for them. Where question of claiming, issuing business card comes, I am director of so and so, so and so. Then you claim yourself as if you are the only VIP on the earth. When question of liability comes, you say I'm.
Companies Act, we are not involved in the affairs of.
May or may not be Companies Act, we will ignore for the timing. We are, Mr. Pava, we are considering under 142. No company law, no other statute can be impediment.
Yes.
And this business of CRP, this insolvency, we are not going to accept it.
Yes.
We will auction all the properties under the court orders and see how the people are paid.
Yes.
Now, my lord, at the same time, allow me also, my lord, just one moment. My lord, I am appearing for respondent number 2. This is the Parsavnath Hessa, a
Who's
private
the
limited.
baby?
Now, my lord, that company is a subsidiary company of the main Parsavnath Limited,
This
which
kind
is a
of
listed
bogus
company.
entry they keep on making whole day. We know these crook business persons. We don't want to say anything more.
Allow me, my lord, to just say 2 sentences. Now, my lord, the 3 directors in the company, all are the employed director, never held a single share
No.
in the parent company
Let
or
it
in
not
this
be.
company.
Let it not be.
My total salary is 35,000 rupee per month.
Yes.
That is the total salary I have drawn over a period of time.
Whom
Now,
are you befooling, Mr. Uda?
Yes.
First, we would like to know.
Lord,
There are 3 judges, those who have
Lord,
really seen this kind of fraudulent
but
pleas
Lord,
and
let somebody, my lord, look
how the
into
documents
the
are camouflaged,
functioning.
faked and bogus pleas are taken.
Respondent number 3. Question is that one bank account which was opened during the CIRP for the process.
No.
That may be.
Will not allow to draw a single penny
Yes.
till all these persons who are running from pillar to post are paid their entire amount along with interest.
Yes.
And next time the order will be to send jail. We are again warning.
We are conscious of.
Let there not be any second misunderstanding about our order.
We are conscious of your lordship's, the order itself, in fact, reads in that way. But what I'm saying is, lordship may at least allow me
Next Monday.
use
My lord, we will.
the accounts which have been frozen. I can make entire payment, I'll make the entire payment.
No.
I am saying so, Lord, on instruction. We make the.
File an affidavit that this much amount is lying in so and so account and you are ready to pay.
Yes,
Lord, kindly grant us about 2 weeks.
Give us the
time, my lord.
details of the entire amount lying in different bank accounts.
Everything,
Lord,
upfront.
kindly, my lord, grant.
All this had to come only after these people had to come to the Supreme Court after 20 years.
No, no, my lord.
Would you not have paid it earlier?
When I tell you a fact.
How many court orders, how many
It's
warrants?
complete. No, this is only delay charges.
No.
The flats are complete, 700 flats have been occupied,
When was
500.
the cost against?
Flats,
Actually
flats,
incorrect.
we will auction the flats for payment of hundreds and thousands of other investors.
Yes.
Those who have not come to the court so far.
Total number of flats are, my lord, 789.
not disclosed all that.
700 flats are already occupied.
Occupied, my lord.
Now, my lord, these are only out of 18 tower, 4 towers have not received OC.
That's not correct. They have not been, not even the wiring has been done, not even the plumbing has been done. They're absolutely bare.
Tower.
And they're putting pressure on me and an 80-year-old person,
Tower.
saying that you take it as is, but we will give it to you provided you give up your compensation. Provided, this is the pressure of the last 2 months they have put on me
fact,
as an 80-year-old
there are
person when I've been
38
visiting their office. Even last week, they're saying, give up your compensation, give up the execution proceedings and take it as it where is. But where at 80-year-old am I going to spend 1.5 crore to furnish the whole flat? Not a single wiring done in my flat. I can produce the photographs. Not even the
38
plumbing
flats,
done.
my lord, in this tower, there are 38 flats, 30 are occupied, families are living there. It's only 8
And they have done it from their own pocket.
taken possession.
They have-
And I would say
that's
rightly
correct.
so, because OC is yet to come.
No.
For this building. And my lord, there are issues of the OC with the parent company, which is
Like,
CIR.
not comply with the order.
Yes.
We are not appeased by this kind of statement, 30 are occupied, 10 are unoccupied, this and that. When you start people harassing endlessly, some of them must have compromised with their fate.
Yes.
This impression is correct.
Does it mean that everything is legalized?
We are
Lord,
not
let
saying-
us
we are
make,
not
my
even
lord,
contesting it.
my lord, what I humbly submit is we will make genuine attempt. Kindly
No.
grant us at least 2 weeks time, my lord. That's
Genuine
it.
attempt, whom are you telling and about whom are you telling? Genuine attempt, as if you do not know about these builders.
But Lordship,
My lord,
week's
still,
time is all that.
huh?
Whole country knows there are fraudulent activities.
Week's time.
Deeply obliged.
We'll keep the account numbers with the amounts, sir.
If you have account number right now, give us the amount,
We don't have.
Treatment
Right?
listed tomorrow.
That time I would have.
because accounts must be so many.
Commission is starting tomorrow.
Poor people are being forced to run.
Whatever I've been disclosed, I will put before your lordship. And absolutely honestly.
My lord, we'll file our respective
And all the
affidavits.
Delhi accounts are there, madam. They have bank accounts in ICIC, HDFC, State Bank, all access all in Delhi, in Barakhamba, because the company is registered in offices in Barakhamba Road registered. So they have all the accounts.
Already comprehensive directions have already been given, which covers everything.
Choice is only between two. Let's be very clear. Entire payment along with interest, additional interest of 12%. The cost part we will determine later on. That is one choice. The second choice is on Monday to go to jail.
But
We will treat the same way as Unitex people were treated. That is the only way.
this case, this is not that. With due respect, I'm keeping my, let me say, gunpowder dry for the moment. That's all. There are other things in this which have not been placed on record. I'm sorry. I'm like, next week.
Yes, that's right.
32, Malad, is a question regarding integrity pact. There are two views. Supporting.
Application for taking.
Acha.
Because of this order sets for tag with
Please go home.
Here for the other cases.
Supporting.
आपकी भी SLP, आपकी भी SLP.
We are also a petition.
You are also petition.
तो मुझे हार्ट अटैक दे saying that we can support each other.
You should give me a chance.
Sorry?
They only the data application. Actually, whenever they consider the matter that stand has to be seen. It can be detailed, but the record should be made available whenever this matter is taken.
Taking the receiving. Record maybe can be, it's not forbidden.
So, causeless is only detagging.
Item 32, 32.1.
This is an application we have filed, my lords, seeking detagging of this SLP, your lordships. In fact, on 13th May 2020, my lordships take that order, my lords, while issuing notice, my lords, had called, my lords, the records in criminal appeal number 152 of 2025 and fixed the matter for final hearing on 29 July 2025. Now, my lords, the registry, my lords, instead of getting those records here, has tagged this SLP along with that criminal appeal, because of which, my lords, that matter has not been heard. All I'm seeking, my lords, is either your lordships will detag that criminal appeal, or, my lords,
No, you want your appeal to be retagged.
my SLP to be heard, my lords, because your lordship fixed on 29 July 2025 for final disposal, my lords. If your lordships have the order, page 11 of my IA, my lords.
No, who is there item number for this 32?
32, my lords, is that criminal appeal record which your lordships have, my lords, had tagged along with this matter.
May I suggest, my lord, I think that will take care of his grievance. Lord, his contention is that since my lords were pleased to direct that record be kept here, record of criminal appeal while hearing the SLP, according to him, the SLP is not
Criminal appeal is pending where?
Yeah,
before this court.
yeah. Straight away.
Before this court.
It's a leave grant.
One option subject to your lordship's approval can be, both matters can be listed on the same day without tagging it. So that the papers are also here. That's not the intention of your lordship's order. I'll just read. Record of criminal appeal so and so be
No,
checked along
criminal-
with this matter.
Criminal appeal is listed for some other bench.
Some other bench. But today, my lords, it's before your lordships because we have filed an application. What the registry has done is, my lords, has tagged this SLP, my lords, challenging the judgment of the division bench of the Delhi High Court with the criminal appeal.
But what is the main case if you decide it? What is the main case?
Main case integrity pact, that is civil dispute. My lord, another option can be, the Xerox copies can be made by the registry of the criminal appeal
Yes.
and can be placed before your lordships in this SL, so that your lordships can peruse the, I think. that-
Yes. That's very good.
So.
Yes.
No, in the Supreme Court itself, what is the problem? That record if the other bench is hearing the criminal appeal, that very record can go there.
That appeal has not come up for hearing, my lords. What your lordships, just have your lordships order of 13th May 25, my lords. Your lordships wanted to ascertain the stand of CBI.
Because they are opposing the.
If your lordships have the order of 13th May 2025, your lordships issued notice, my lords, paragraph 3, 2025.
IA number.
Yes.
So IA number.
This is IA, this is item 32.1, my lords, IA number
Three in the second
78373.
matter. The orders
Page
are in the
11
second
and
matter.
13.
Madam,
IA 78373.
So whatever relevant order will be there, they will never tag it.
Page 13.
13th May, what is the order of 13th May?
13th May 2020.
That-
You have extra copies?
Nice.
Lord, may I give for your lordship ready reference, sir?
So that para 3 record of criminal appeal number so and so.
Yes, be
Yes.
tagged along with this matter, which is the,
For perusal of the stand taken.
yes. And my
What
lord,
was the stand of the investigating agency
Yes,
that?
That your lordship was required, my lord, were wanting to know. So therefore, my lord, suggestion, my lord, I think is agreeable is that the Xerox copy of that criminal appeal record
Yes.
may be kept along with this special
and this
SL.
matter be listed, my lord. In fact, your lordship had fixed it on 29 July 25.
Yes, SLP, let us see the.
So the criminal appeal arises from the predicate offence.
Yes, ma'am. The predicate.
And this is the ECIR.
No,
This, my lords,
no.
arises, my lords.
Both are criminal appeal only.
No.
First is a civil appeal
Civil matter.
concerning a
The award of
award of contract where, my lord, the tender document provided for a particular integrity pact and the disclosure about the criminal antecedents and what is the interpretation. So first is a civil issue, my lord, purely. One view is taken by the Calcutta High Court, another view is taken by Honorable Delhi High Court. But that's the,
What has happened is the criminal appeal is shown as the first matter.
Yes, yes,
The
that's
other
why
report
the
comes
leadership is
without-
right.
so Therefore, there is a.
That's why, my lords, this matter is not getting listed for yes.
So what is this RK Associates and Hoteliers Private Limited and
My lords,
matter?
they were awarded the contract, my lords, for onboard catering services. My lords, we were, my lords, the L2 bidder, my lords. So we challenged, my lords, the award of tender before the High Court, my lords, saying that they suppressed, my lords, the two criminal cases which were pending against them, my lords, which was required to be disclosed under the Integrity Act, which was to be filed, submitted by all the bidders. Now, my lords, the High Court held that yes, there are two cases, the CBI case and an ED case, which was suppressed, my lords, from the tendering authority. So High Court holds that the disclosure under the bid is mandatory and non-disclosure, my lords, disqualifies the bidder under the CVC guidelines as well as, my lords, the tender document. High Court, my lords, follows a division bench judgment of the Calcutta High Court, Damodar Valley, saying which holds, my lords, a similar interpretation which the Delhi High Court has held. Now, my lords, so High Court quashed the award of the contract, my lords, to RK Associates and directed that a fresh tender be issued. And till the fresh tender is completed, he should continue. Against that, my lords, an SLP was filed before your lordships. Your lordships on 13th May, while issuing notice, my lords, listed the matter for final hearing on 29 July 2025. During the hearing, my lords, in a point raised was that in the predicate offense, which was, my lords, the CBI case, that has been stayed by the court here in Criminal Appeal 152 of 2025. Whereas your lordships then called for the record saying that we want to see the stand taken by the CBI in that case. Because here, my lords, there is an SLP filed also by IRCTC, my lords, which is the tendering authority challenging the judgment of the division bench of the High Court. The issue is only that, my lord. Now, because it is tagged with a criminal appeal, my lords, that goes in the regular list. This matter is not getting listed, my lords, for last morning.
Correct.
well, let it be TD tech. I have no difficulty, my lord.
Oh, then better we send back the criminal record and the stand of the respondent, one can see and a copy of the affidavit, that's all.
We'll place it.
Yes, whether the integrity certificate is
Yes,
required,
yes, yes,
that's the only
yes.
issue then.
That's
that
right.
can be
We'll
done.
place it.
But IRCTC also has filed an SLP.
Yes.
against that.
Yes, ma'am.
Say, the para 3 of the order dated 13th May 2025, passing SLP civil number 13053 of 2025 is recalled and record of criminal appeal number 152 stroke 2025 is ordered to be returned to the registry. Is returned. Post of the registry directed to this criminal appeal number 152 stroke 2025 along with the record before an appropriate bench after obtaining necessary order. The stand taken by the investigating agency in the above state criminal appeal may be shown by way of photostat copy of the counter affidavit or any other relevant document that is part of the record of criminal appeal number 152 of 2025.
My lord, arguing counsel is appearing through VC. 33, your lordship. Arguing counsel is appearing through VC.
May I please your lordship?
I am appearing for the state respondents, my lord.
Am I audible, my lord?
Yes, yes.
Your lordship, the stand taken by the state respondents, they support our case. We have perused the affidavit. They're saying that the state government is saying that the High Court has erroneously passed the judgment. The basic issue was that whether a person who has been elected as a member of an autonomous district council under the 6th schedule can simultaneously hold the office of the member of legislative assembly of the state assembly. Our argument was that in the spirit of Article 190, you can't do that. And accordingly, when your lordship was issuing the notice, your lordship has observed that as far as the Lai Autonomous District Council and other council was there's an explicit provision was there that you cannot have dual membership. But as far as Sakma Autonomous District Council is concerned, they by the amendment, they took out the office of the MLA. So by virtue of that, what is that? A person who gets elected as a member of CADC, he can simultaneously occupy the office of the member of Legislative Assembly. That is the main issue. And the learned High Court, what the division bench did was said, your lordship will kindly come to the impugned judgment. The observation recorded, my lord will kindly come to the page 18, para 24. My lord is there?
Yes, yes, fine.
My lord, what is the, it is a long para, but the surmises is that, the ratio is that the high division bench said that it is a policy decision why this particular MLA office has been kept intact and the High Court cannot read into it. Though High Court thinks that yes, it should not be, but High Court said that we cannot look into it. This particular finding is perverse in light of the judgment passed by your lordship in Po Milai's case, where the issue was that how do you administer 6 schedules? And this honorable court said the 6th schedule is being a part of the constitution. It is not a mini constitution. So it has to work within the 4 parameters of the constitution itself.
Lordship, I'm appearing for respondent number 10 minutes.
Service is incomplete. Lordship, I agree with the submission of the learned counsel for the petitioner. What I would like to draw your lordship's kind attention
What has
is
the High Court
Para-
done ultimately?
para
So the state accepts it.
Necessary change amendments.
Because our order also,
Yes.
moment.
have you seen our order of 13
Because
April?
for the other autonomous
Lordship.
councils, there is an express bar.
In Lai Autonomous District Council, there's an express bar.
Express bar.
Express bar. But here, my lord, there was a bar. But subsequently, by an amendment,
The rules, the bar has been removed.
it was removed.
We feel that all district councils should be governed in the same scheme.
My lord,
Why should there be a special difference?
My
You
lord.
can, if, as my brother has hinted, if you can restore the case of Chakma and Mara, then
lordship,
then the substratum of law changes and we can clarify that.
We'll do that.
If your lordship permits,
It
if my
is,
lords permits,
it is for the autonomous district council to make their own rules. The state cannot make that, my lord. That is what I'm told. And my lord will kindly see if I can draw your lordship's kind attention to paragraph 23 of the impugned judgment.
No, who has to do it?
Autonomous district council.
It has to be done by the autonomous district council
It's a CADC itself.
because they make their own rules.
Who is appearing for number 7 and 8?
No one has put appearance as of.
Lordship, I'm appealing for the
They have
respondent
not
number
appeared.
10.
They've been served, but they,
Service complete.
yes, service
Service
is complete.
Chakma service.
my lords will appreciate that as far as the LADC was concerned,
Learn counsel for the parties briefly. Stop in continuation of our order, it is 13 April 2026. I am aware of the concerned opinion that all the autonomous district councils ought to be treated at par for the purpose of bar on dual membership. Consequently, we direct response number 7 and 8. We-
Let them come and. R7. We are R7,
Consequently, we direct
R8.
response number 1 to 8.
number 8 is the Chakma.
Seven and eight.
You can take up the matter with the state council, autonomous council. We direct.
Lordship, I'm appealing for respondent number 10. Lordship.
Especially the chief executive officer of the Chakma Autonomous District Council and Mada Autonomous District Council to take up the matter and and restore
Rule 11.
the bar.
Rule 11.
Rule 11.
Rule 11 and 12A, 11(1) and 12A of the CDAC rules.
And suitably amend rule 11 in bracket 1 and rule 12 in bracket 1 small a.
Repeal the amending rule. This was there. This was repealed by the 23 repealed amendment.
This is suitably amend only, we can't say.
2003 amendment.
Repeal amending rules.
Amend so to
Sir, you can say in accordance with.
to restore
Article 1.
Just restore these rules.
and to
No.
Just if we say that
In the restriction.
this will get restored.
recalling
83.
the Chakma Autonomous District Council in bracket constitution and conduct of businesses, etc. Bracket close again in bracket amendment, bracket close rules 2003.
And
As a result whereof,
this will be restored.
the 2002 rules will stand restored.
Bas.
Let an appropriate order be passed within a period of 3 months. Let an appropriate decision be taken within a period of 3 months. That's all.
My lord.
As far as the
Lordship,
rule is
may
concerned.
make a short
My
submission.
lord can
Lordship.
hold the rule to be in. My
My
lord can
lord,
hold
your
the rule
lordship,
is
your
in-
lordship will appreciate one thing. Your
It's
lordship will
ultra-vires the
appreciate one
constitution.
thing.
That will serve the purpose.
My lord,
Otherwise,
They are not represented today. They are not
They are
represented
not.
today. That is why we are giving them an opportunity to take action in terms of our earlier order. If not
But
consequently.
liberty to approach your lordship, but
Well, it will
liberty to
kindly give a
approach your
short
lordship
date,
if they,
The reason is that if
Lib-
they have any problem or if they find any impediment, they will come to us.
So let it be kept pending, my lord.
let it be kept pending, your
Let
lordship.
it be kept pending.
We are disposing of, you can always approach us, they can approach us.
It will again,
Again, because
Have
he
to
is
inquire
holding two
afresh, my lord.
offices, my lord. At present, the gentleman is holding two offices. So if your lordship keep the matter open, or if the lordship says that we will be liberty to approach this court, it's fine. That has been given the
Either-
opportunity because
either let the matter be kept pending before your lordship.
Needful is not done within the stipulated period. The petitioner, or for that matter, the state of Mizoram,
Lordship.
shall be at liberty to approach this court again.
Keep
In
the
this
press.
direction, the matter will be.
oblige your lordship. Oblige.
Keep the press.
Lord, I beg to appear in item 35, my lords. Lordships may hear me, my lord, whenever your lordship.
34.
Yes, sir.
Is modified.
34 not fixed.
Your 34.
35.
What is called out is 34.
Thirty-four, there is the letter, sir.
Yes, my lord, only one thing, my lord, I appear for SBI. We have filed our reply, but it is filed yesterday, so your lordship's paper may not contain that.
And to add to that, because we were waiting for SBI to file replies, so we'll also file by the next date because we wanted SBI's record stand to be there first.
Because I am for RBI, my lords, I will also file a reply, my lords, within 3 weeks' time.
Plus, we are for EY, we'll be filing our wakalat now.
Your lordship.
What has happened, Mr. Commissioner, you are saying something?
No, my lord, I said for SBI, I have filed a reply yesterday. It may not be on your lordship's record, right?
Filed by State Bank of India. Cannot on the court of district to tag the same, post the matter on so and so day.
Your lordship, appearing for respondent number 8, I have filed wakalat number yesterday and the arguing. Counter also I have filed.
I also file.
Within the next date, we'll all file.
Whoever has not filed and wants to file.
Respondents who are yet to file the reply may also file the respective counter affidavit.
My lords, I may be permitted, my lords, to submit few facts, my lords, with regard to functioning of the SIT and all that, my lords. Only 2-3 points I would like to submit, my lords. I'm in item 36, my lord.
It is yet to be called out.
So we don't know, we have not read the brief.
No, no,
We are not.
he is arguing some other matter.
Next matter.
We should at least, my lord, be supplied to the status report. We are not asking for the
Sir,
case diaries,
not
my
this
lord.
case, sir.
Let it be called out.
Item 35, 36, 37 and
Very well.
38.
Yes, my lord. Beg to appear in 37, my lord.
Lord, in this matter, my lord, in respectful compliance of your lordship's
But to that,
earlier order, we have filed status report, my lords. Investigation is going on. 8 persons are arrested. And my lord, I cannot divulge much, your lordships are aware in midst of the investigation, but
we were expecting you to file some status report.
Lord, we have filed. It, in item 36, it would be there because the order was passed in item 36. We could have filed status report only in 36.
Only one matter is sufficient.
Yes, ma'am.
The current SIT who are investigating,
Police is investigating now. Lord, SIT was constituted to examine the truthfulness. It immediately said that yes, there is a cognizable offense made
I
out.
want to know the composition of the SIT
Yes, ma'am.
as mentioned in para 2.
Yes.
Is it still the same SIT who is investigating?
It is not investigating agency at all. It was not. it just, my lord, found out prima facie whether there is any cognizable offence made out. They filed a report that there is, which is also a part of your lordship's cover
Based upon that
report. Now FIR is
registered.
registered.
Now, who are the investigating officers who are investigating those FIR?
My lord, the concerned, my lord, police officers
No.
under the
Is there any
supervision of the
SIT
SP.
Is there any SIT constituted for investigation?
No, my lord. It is, my lord, the concerned officers, my lord, under the supervision.
Sir, we will take up the matter after 3-4 days.
Yes, my lord.
We will also consider, meanwhile, we would like to go through this report.
It seems my lords had
I
no
have-
occasion to
My lord,
read.
my lord, few submissions, my lord, 2-3 lines, my lord, just, I mean,
Unnecessarily, people, we would like to have you to have instructions
Yes, my lord.
that is same SIT, because that SIT was a very senior responsible officer. Commissioner of Police of Lucknow Division, this might be Commissioner or Civil Commissioner.
No, he is a police commissioner.
If
I'm
the-
sorry, he is division commissioner. No, but the police commissioner, not.
No,
this is,
it does not,
he's like a collector.
Revenue commissioner. No.
but there,
IAS officer. He is IAS officer.
there are two IAS officers. One is the Commissioner of Lucknow, that
Yes.
means officer who is above the collector.
Above the collector, yes, my lord.
And another is Special Secretary Finance Department, he also
Correct.
must be an administrative officer, maybe
Yes,
IAS.
he must be at the level of secretary.
But there is another officer, member of he is the Inspector General of Police Lucknow range,
Yes,
a very fairly senior IPS officer.
yes.
So please have instruction that let there be an SIT for investigation, ongoing investigation, and that SIT can be headed by this officer because he has knowledge of the.
I have no objection. I will assure that SIT is constituted and placed before your lordship.
So you speak to the Director General of Police,
I will.
get the SIT reconstituted, headed by this officer who has earlier seen.
Yes,
who
yes.
has a prima facie knowledge of everything.
And some senior level officials can form the part of the SIT
That's it.
and they may be supervised by number 3.
Meanwhile, we will go through this report and whatever additional directions are required to be taken, issued, we will do that.
Lord, one
my lord,
submission,
we have
just one
very
second.
precise, my lord, we
Lord,
have
just
very,
one
We are only putting a word of caution. Don't play any politics. The courts are not meant for
Correct,
politics.
my lord. Lord,
Don't politicize the issue. It's a simple
yes, my lord.
my lord,
prima
state, my
facie
lord,
case of commission of an offence
Correct,
under the penal laws.
correct, my
It
lord.
must be investigation in a fair,
Absolutely.
impartial.
absolutely.
Lord, and we have no
And
doubt.
Even the
Investigation
Just
must
one
be taken to a logical conclusion. That's all. Beyond
state
that,
is not, my
any-
lords.
Lord, just 30 seconds, my lord. Lord, we have raised in our PIL, which is item 37, a larger issue, my lord. And we are quite confident, my lord, under your lordship's gaze, my lord, the investigation is going on, etc. Now, my lord, what has happened here is, my lord, there are 3 aspects which will, my lord, need, my lord, your lordship's consideration. When, my lords, the temple was being built, my lord, the trust sought funds, my lord, from every devotee, from every corner of India, and receipts were taken, my lord. My lord, it has come to light and we have pointed that out. Ultimately, my lord, the money has not reached, my lord, the temple. So that is one aspect of the matter. So one of the suggestions which we have given, my lord, is that all the receipts, my lord, which they say, my lord, are with the trust, people have given money, my lord, 100 rupees, my lord, 50 rupees, etc. Receipts were given. Let them be disclosed, my lord, on a website. My lord, let people know whether their money, my lord, has actually reached. That's one of the suggestions, my lord, which we have given.
not necessarily website, but there must be a well-maintained
Yes, my lord.
accounts
Yes,
book.
my lord,
Correct,
in
my lord, that where people,
investigation, everything.
lords, where
to be
people
seen.
can, my lord, have a look.
The record should be well-maintained.
Yes,
Yes,
the
yes,
second
Lord,
aspect, just one second. sir.
investigation, everything
I-
will be seen and my instructions
correct.
are, my lord, not to obstruct any suggestion coming from your lordship.
Lord, I'm
or
grateful to my learned
oppose.
friend.
Lord, whatever, my lord, is required
Lord-
for the purpose of fair, neutral, impartial and transparent investigation.
I'm grateful to my learned
Lord,
friend.
yeah.
Lord, the second point, my lord, is lot of, my lord, devotees have given, my lords, like for instance, my lord, their own silver, my lords, ornaments, gold, my lords, has been given. Now, my lords, the account of that, the trust, my lord, and the state should disclose, my lord, that this has come. They may not be, my lords, named, but at least, my lord, this is the donation, my lord, which we have. Somebody has given a gold brick, somebody has given a silver brick. Today, my lord, reports are there that these have completely vanished. So therefore, my lord, an inventory.
Tomorrow, Mr. Kamath,
Yes, my lord.
we will have to be very practical in certain aspects.
Correct, my lord.
People will start coming. I had donated a diamond.
No, my lords, we are not,
Diamond.
my lords, we
Where
are
was
not
the
talking
diamond from
about,
So-and-so country, where is that?
my lords,
People are also.
yes, my lord,
very
but as far as receipts are given, my lord, and they have the receipts.
Receipts are given.
Yes, my lord.
This is what exactly we are saying.
Correct, my lord.
Wherever the receipt has been issued.
Yes, my lord.
That record should be well maintained.
Yes, my lord.
Should be accounted for.
Correct, my lord.
It should be like ledger books are there.
Absolutely, my lord. I'm grateful for that. Either it can be put on the website or for inspection or whatever, my lord. But I've raised those larger issues, my lord, which your lordships may consider. They can file a reply to my petition.
My lord,
Then my lordships may consider.
my lord, very small
My
point
lords, very
for
small
15
submission, my
seconds
lord.
only, my lord.
At least,
For-
FIR, state should, at least, my lords, upload the FIR on the designated portal.
Smallest request, my lord.
To go through this report and then we'll take up. the-
State has not uploaded the
At
FIR, my
least-
lords, on
at least
designated portal.
permissible evidences must be preserved, my lord, because for the transparency and honesty, CCTV camera, DVR records, and these records must be preserved. So very narrow direction, my lord, it will pass.
To be preserved, and they are being preserved.
I am the first person to file a writ petition before the Lucknow High Court. My lord, I way back on 15/6/2026. My lord, thereafter, after 22nd, this matter has been filed. On 29th, it is mentioned. Therefore, my lord, on 7/7, the High Court says that since the Supreme Court seized of the matter, and it is disposed of. My application for my intervention is my way back.
Now we are seized of the matter. You withdraw your petition. What is?
Already withdrawn, closed, and my lord, therefore I am before the Supreme Court. The office court notifies by IA also.
Is it necessary for everybody to come to the court? When we are taken cognizance of a matter, we are ourselves monitoring now everything. Is it necessary for everyone to be in the list of
Larger issues have been raised.
larger issue anybody can raise?
Hear me on the issue, my lord. I will.
We will hear.
My lords, only two requests, my lords, only two requests, my lords. State may be directed to upload the FIR on designated portal, my lord, despite lapse of a month, my lords, almost. That is not uploaded. And second, my lords, we are not asking for the case diaries. We are just asking for the status report, my lord. At least copy may be supplied so that we can be of any assistance to this honorable court.
We will see what is to be done on next Monday. We'll pass on direction.
FIR should be uploaded, my lord. This is a standing direction of the courts, my lord. They have not level up transparency of the state.
Thank you very much. Thank you.
My lord, now everyone has filed a, my lord, application. My lord, your lordships may, that's my request. Confined to the petitions filed, there are prayers. Otherwise, my lord, it becomes unmanageable.
Lord, by the next date, my lord, my learned friend, my lords, can file the replies or the suggestions can also come to assist your lordships, my lord. We have filed those, the petition, my 37. Yes.
Reply is not going to.
The investigation is going on. my lord.
Not on larger issues other
Better
than.
advise-
Investigation is being carried out by the circle officer, Ayodhya, my lords, not by the SIT.
What is the application? We will consider everybody. This,
Yes, yes.
we will see what is to be done.
Obliged.
Your Lordships, yes, Your Lordships, I'm the proxy counsel in this matter, Your Lordships. The,
There is no, we don't grant such a license. Proxy counsel or absentee counsel or present counsel.
Your Lordships,
Counsel is counsel.
Your Lordships, the senior counsel in this matter is out of town due to some family medical emergency.
It is a golden opportunity for you to encash. You should argue the case and you can tell the senior arguing counsel, main counsel that the bench do not give the adjournment. Therefore, I had no choice but to argue the case.
Your Lordships, I humbly pray for a short adjournment. Your Lordships, we have also moved the adjournment letter. However, the same could not be placed on record, and we have also intimated the learned counsel for the respondents, and they have no objection, Your Lordships. I humbly request, Your Lordships.
No, that request we might turn down. Yes, what do you say? Are you appearing?
My lords, I'm appearing on
Your
behalf
Lordship,
of-
I beg to appear for the state, Your Lordship. We've put in our counter affidavit, Your Lordship will find from the counter affidavit that the grievance of the petitioner stands redressed even prior to filing of this writ.
Your Lordships, any short date would work. I humbly pray.
We might not grant. Now tell us why this matter should not be remanded to the High Court. Where the decision on merits?
That adjudication, I quite see, your lordship is right. That adjudication has not come, but by way of my counter affidavit, I've placed on record the developments which were in fact placed before the court.
Improved order is just an extract of some other judgment and then say, so we agree.
The- And your lordship, in the order issuing notice, has in fact framed the issue as to whether this is a fit case for remand.
The appellant is agreed by the judgment dated 31st October 2025, passed by the Division Bench of the High Court of Judicature at Allahabad, Lucknow. Among terms whereof criminal petition filed by the appellant has been summarily disposed of on the ground that he had earlier approached the court on 3 occasions for quashing of the history sheet number 376, capital A stroke 2009 at police station Jankipuram, Lucknow. And appropriate orders were passed in those petitions. So in other words, the High Court has, don't say in other words, the High Court has reproduced the previous order passed in one of the cases and has accordingly disposed of the petitioner's appellant's petition without going into the question whether the history sheet under challenge is liable to request stroke closed in light of the supervening circumstances, including acquittal of the appellant by judgment dated 5th July 2014 in Sessions case number 584 capital A stroke 2008 arising from FIR number 365 stroke 2007. Next paragraph. Though in the counter affidavit, the respondent state has taken the plea that active surveillance and routine monitoring against the appellant has been formally closed and discontinued on 17 October 2021. However, it is insisted that the history sheet a permanent informational repository and thus it cannot be destroyed. This issue, comma, in our considered opinion, comma, deserves to be adjudicated by the High Court on merits after considering the rival contentions. So consequently, the appeal is allowed, the impugned judgment of the High Court is set aside, and the matter is remitted to the High Court for fresh adjudication of criminal miscellaneous writ petition number 1356 of 2024. We will appeal, we request the High Court to decide the petition expeditiously and preferably within 6 months. Now, is it okay?
Grateful, Your Lordships.
Or you still want a date?
Grateful, Your Lordships.
Grateful to your lordships.
Please, Manoj. Yes, Your Lordship. The state has filed its reply a day back, Your Lordships. It would not be on record.
Sir, you filed a reply on
Lordships may
Saturday,
have
my
it
lords,
all
not on
next week.
record. My lords, if I may just apprise, my lords, respondent number 2 accused has not been served in this matter, my lords.
Sentence we were not increased. Compensation for this.
He is appearing for the respondent number 2.
My lords, he has not been served
has
as
not
per
been-
the office report, my
The
lords.
service has not been complete on him.
As per the office report, respondent number 2 has not been served. As no such person has been found to be residing at the given address. Which is the police station area?
Tabraharpur, Your Lordship. Tabrahar.
My lords, it's Tarbahar, Bilaspur.
The superintendent of police of district Bilaspur, as well as SHO police station, Tarbahar,
Yes, Your Lordship.
Tarbahar district Bilaspur are directed to effect service on respondent number 2 and secure his presence in court on the next date of hearing, telling which they shall be held responsible for non-appearance of respondent number 2. In case the said respondent shows any resistance, the police authorities, and it is made clear that if respondent number 2 will still evade service, comma, we will be constrained to issue non-bailable warrants. Now it is your SP
My lords.
and SHO duty.
My lords. Please, my lords.
Post on so and so date.
You be opposed.
My lords, we have, this is the special courts, my lords. We have filed status reports on 17th July, my lords. I have made a summary of that. So in the NIA special courts, my lords, there is good progress. 14, now total 14 exclusive designated courts have been established, my lords. I have made a summary of the status report for NIA courts, my lords. So your lordships will see, my lords, Jharkhand. So total number of cases 27 and 3 courts have been designated. Jammu Kashmir 1, Maharashtra 2, Bihar 1, Gujarat 3, Chhattisgarh 1, Manipur 1, Assam 1, Punjab 1.
No, the most dangerous thing is designated.
So notification, consents have been done, it's being processed, notification within a week it will
No,
be.
no, what about the exclusive court?
This is only exclusive courts data I'm giving to your lordships. So 14 are established, Delhi, just notification remains, my lords. We have explained that in the affidavit, in the status report, my lords. The approval we have on 16th of July. Just the notification remains. Para 6 of my status report, if your lordships will have along with that. This note I made only, so your lordships have a bird's eye view of where we have achieved, and my lords, we are with the rest of the states, my lords, Telangana, Andhra,
No, but
Karnataka,
exclusive court in Delhi also only three.
3, my lords.
Three.
So 50 trials are there, my lords. If 3 are designated, because building, the judges are, honorable judges are all available, my lords. Just the final notification is required. Within a week, this will be done, my lords. Now, my lords, we need a little more push from my esteemed colleagues, my lords, the learned AGs of Telangana, Andhra, Karnataka, Kerala, Tamil Nadu, Rajasthan, and West Bengal. So we are at advanced stage, my lords. We should be able to achieve.
How much time according to you they will do?
My lords, maybe about 4 weeks, if your lordships may deem appropriate, my lords. Your lordships' directions are very clear, my lords. They are actually hand-holding us and allowing us to proceed in a good manner, my lords. So 14 designations is also a good achievement in my respectful submission, my lords.
3, 4 only DPS. What about para 10 information of the last order?
Yes, my lords.
States had to file.
Yes, my lords. States have filed also affidavits, my lords. But I am giving your lordships a bird's eye view of.
Mr. Sanjay, you are still carrying dual responsibility.
My lords, I'll assist your lordships.
No,
on
my lords,
DPS.
now,
My colleague.
my
will
lord,
appear.
now I am not carrying dual responsibility. Now today I am representing only Bihar, my lords. And my learned
Of
friend,
course, I had the
Ms.
benefit
Bhati-
of a discussion with him. I took the briefing, I took inputs from him and I've then spoken to the officers.
my lord,
For
so far
NDPS
Bihar is,
also, we filed a
Bihar
status
is
report. my
concerned,
lords.
one notification is
NDPS,
only to
so the
be
entire
made.
exercise of assessment, that status report was also filed, my lords, on 17 July. So, my lords, the total lordships had.
Our criteria was that average 15 cases or less than that. What do you say?
Yes, my lords, your lordship said 15 cases. my lords.
So the next page,
Yes, my lords.
like Assam, Arunachal Pradesh, there are 18 cases.
Yes, my
So
lords.
maybe one court, because that's only a flexible guideline.
Please, my lords.
Yes.
Bihar 16, but one court is sufficient maybe.
Yes, my
No, my
lords.
lords, even for second court also, for Bihar, my lords, with respect to second court, a notification is pending. I think within a day or two, that notification will be made by the Home Ministry, my lord. So there will be 2 courts exclusive for Bihar.
2 courts. In Bihar, you require 2 courts, Mr. Sanjay. That's why it's.
Your
the right
lordship, so,
approach
my lord, on a second, with respect to second, one is, my lord, ADJ 26, my lord, and with respect to ADJ 15, my lord, both in Patna, my lords, the request has been made to the Home Ministry for issuance of notification. And I hope that within a week, my lord, that notification will be done. So 2 exclusive courts for trial of 16 cases of NIA will be there in Bihar.
All right.
Yes, in Maharashtra, there are 20 cases and there is one court notified as a special exclusive court last week only. We have only 20 NIA cases.
Dr. Sathya,
We have
you are
20 NIA
notified 2
cases.
courts, I think.
Yes, because we have only 20 cases.
20 cases, but ideally 2 courts are, of course, very.
No, because there are 5 designated courts, out of which one is exclusive.
All right. And
My lord,
in
so
Punjab, Haryana, and Chandigarh, there are 32 cases. Only one court appears to be in SS Nagar. What about Haryana?
My lords, I am appearing for Haryana. My lords, I am appearing for Haryana. My lords, in June, we had notified the court for NDPS and for NIA, my lords. For NDPS, my lords, we have exclusively established.
On NDPS, we are on NIA.
My lords, NIA, my lords, we notified, and my lords, we have notified one court for NIA, my lords, on 23rd of June 2026.
Where have you notified?
My lords, it's an Administrative Justice Department, my lord, notification. My lords,
Where the court has been set up, which place?
my lords, that is not mentioned. I'll place it on record, my lords.
That is problem.
My lords, I'll
Your
place it on
officers
record.
are expert in documentation, but on ground reality, zero.
My lords, it says, my lords, I'll read. It's been session judge in District No for trial pending cases registered. It says no.
District, no, is there any exclusive court for entire Haryana?
My lords, that I will place it on record because the notification says only NIA in District No, my lords.
If you want to have one court in the throughout the state, why are you bringing in one corner?
My lords, I'll seek
You
instruction.
have in the middle of the state.
My lords, I'll seek instruction.
My lord,
This
insofar as
notification
Telangana is
from
concerned, my
22,
lord,
my lord. So they will need an exclusive court under section 11
It
also.
can't be exclusive court.
Yes, my lords.
My lords, it's in the code.
So they have done nothing. Ultimately,
my lord, so far as Gujarat is concerned, we have got 3 exclusive courts. There are 13 trials. One is already started working because it was notified on 17th March. Two have been notified just 2 days back. I think within 10 days, they will also be started functioning very well.
How many cases are there, Mr. Trivedi?
There are 13 trials. Witnesses are more. There are about 745 witnesses to be examined.
All right.
State of Telangana, we have designated one exclusive court, my lord.
And
We
how
filed
many
our affidavit
cases are
to
there, Mr. Reddy, Mr. Advocate General, how many cases you have in Telangana?
17 are there, my lord, except only I filed it at annexure A2, my lord, that there are only trial in respect of 4 cases, my lord. All others are pending, my lord, consideration for charges.
All right.
Your Lordships, I appear for the state of Uttarakhand, Your Lordship.
Yes, Mr. Bhatia, what is the position in Uttarakhand?
Your Lordship, Uttarakhand has no cases pending under the NIA Act. And for NDPS, we have established 5 courts, Your Lordship. 5 courts. And 4 more have to be established, would be established very
Are
soon.
these going to be the exclusive courts?
I'm sorry?
Are these going to be the exclusive courts?
Yes, Your Lordship, the 5 that have been created are exclusive for NDPS, Your Lordship. And we also wish to file a response, Your Lordship, bringing this on record.
All right.
Keep your blessing.
So then what we are doing is that we are granting 4 weeks more time, as pointed out by Madam Bhatti. But make sure that all these states, wherever NIA courts are required to be established so far, and issues are pending, you please do the needful. We don't want to linger on this matter further.
My lord, in West Bengal, my lord, 2 courts will come into effect on 3rd August. And my lord, the High Court has filed an affidavit to that effect.
In West Bengal, the matters are total 21.
21
courts are sufficient.
According to this, my lord, report it is 21. Actually, my lord, it is 67.
But that would include the state cases also, madam.
I think figure given to us is 21 matters.
This is section 11 trials by the
Government is-
PA, my lord.
State government.
Yes, of course. So that's all. So, my lord, when your lordship is providing for special courts, the state cases also have to go there to the same courts, my lord.
Mr. Gupta, see paragraph 10 of our order.
Yes, my lord.
They are different.
Yes.
The courts are different.
So these 2 courts are meant for the,
Only for
your lordship wants it only for the NIA.
only
The
for the NIA.
central NIA.
The central agent.
Lordship.
Section 11.
1021 is okay for that. 2 courts is enough for the time.
2 courts can be sufficient.
Yes.
Mr. Gupta, follow up paragraph 10 with regards to the state prosecutions under the law.
Will.
So that if you can have 2 more for the state.
Sure.
Anyone for the state of J&K and Ladakh? Madam, Priya,
Please, madam.
we need to have a success from J&K and
Lordships, please.
there are 47 cases.
Yes, madam.
And that state there must be more matters in that case.
Yes, ma'am.
maybe. And there is no court or 1 court so far, that
Yes.
cannot be sufficient.
Yes, madam. I'll take instructions, madam.
So in deference and in continuation of the previous orders that is so and so. Our further status reports have been filed by the High Court of so. The full name. Giving details regarding establishment of exclusive courts to try NIA cases. Where prosecution is by Union of India. Where
Prosecution by NIA. By NIA. Is by NIA.
Your Lordship, may I make a submission? If possible, kindly grant some time to file the status report for the state of Tamil Nadu.
We'll grant you time. We are granting 4 weeks time.
Okay, much obliged.
As per these affidavits and the information given in a tabulated form by Ms. Aishwarya Bhatti, Learned Additional Solicitor of India, the number of NIA cases pending at various stages of trial, including charge sheet, etc., are as follows, along with the corresponding exclusive courts designated in those states, which are also depicted in this chart. A chart as paragraph. We find that in some of the states, no effective steps for establishment of NIA courts have been taken, whereas in a state like Jammu and Kashmir and Ladakh, the setting up of one court is expressly inadequate, keeping in view the proper tendency of 47. As per the Judicial Section of India states that efforts are being made in coordination with state governments and the high courts to comply with the brief direction and bring and set up the courts at the earliest. She states that should we grant 4 weeks more time, the necessary NIA court shall stand established. So in this view of the matter, post this matter, in this view of, in light of this submission, post this matter on so and so date for further consideration. A separate status report with respect to NDPS cases we also filed. With respect to exclusive NDPS cases, we also filed on the next date of hearing.
Malad, NDPS, may I just give your lordships an indication of what is so far? Because NDPS, your lordships have directed us to do a comprehensive exercise. That exercise is complete by all states, Malad. So the identification is total 394 courts are required, out of which, Malad, 113 have already been set up. That your lordships will find in my status report, para 8 and 9, Malad. So we'll file an updated status report in 4 weeks and Malad, bring on record the status.
As we got to NDPS court cases, exclusive NDPS, exclusive courts for trial of NDPS cases, it is pointed out by Aswari Amati, Judicial Section of India, that now just give the figure.
Yes, Malad. So total requirement that has been assessed by all states and union territories is 394.
The total requirement is 394,
Out of which, Malad, 113 have already been set up.
out of which 113 have been set up. She submits that meanwhile some more courts might have been
Please, Malad.
established. She seeks 4 weeks time to give the latest status with respect thereto. Then she post the matter on so and so date.
So I appear in 41.1. That's the bail matter. That may be also kept.
Yes.
Malad, all my colleagues are here, Malad. They will continue to, Malad, assist in your lordships, Malad, because their help is very instrumental in getting this.
Undoubtedly.
Yes, Malad. Grateful, Malad.
Grateful, man.
You're grateful.
Meet these lordships. Item 42, Bharat. Bharat, may kindly peruse order dated 15/6/2000.
Same thing is instead they can be applied for all the courts in the.
Yes, my lord, so there are 180 cases in my affidavit. We have done the verification. Now there are 4 police stations left when they are doing the verification, because basically they need to take the surety documents from those 2 sureties and they have to be submitted in the respective court. Everything else is verified, my lords. We have no problem if he's released in bail. My lords may just indicate that, because as per my understanding, every trial court requires the surety to come. Because the original, they look at the original RC and they look at the original, we have verified them, the police of the respective districts in these 180 cases. So my lords may just pass that direction, because this is the issue that they are also facing, because
How long you will take?
well, we are done. There are only 4 police stations left and they'll also be done quickly, because 180 we have done. But the modalities on the actual grant of bail, the actual release on bail, because the respective court looking at the matter requires, when I understand, because the sureties are in Ghaziabad, for them to travel all over the, 1 second,
Sorry.
for them to travel.
Can we say that in view of the fact that out of 180,
Cases, 180 cases, only only four cases remain to be verified.
11 cases in
No, no.
4
cases.
After that, we have done more. My affidavit is last week, so now.
I was not aware.
Only 4 cases are yet to be verified.
No.
Say, according to London State Council, according to London State Council, out of 180, only 4 cases of 4 police stations are yet to be verified. So, that being the state of affairs, from we direct the petitioner to be released on bail, furnishing a single set of bail bonds for all cases.
Very.
That
My lords, we note.
single set of bail bonds should be set to the satisfaction of the.
My lords, there are multiple trial courts. The problem that is happening, if I may point
Have
out.
already passed this order.
How many districts?
So, my lords, there are four districts. Four districts.
Four bail bonds
Hathras,
filed
Farrukhabad.
in the Chief Judicial.
No,
No,
in
my-
total, my lords, there are many districts. I'm saying 4 districts. In total, my lords, the districts are.
The problem which is coming up, my lord, since the courts are insisting to appear before them, the 2 sureties, my lord, there are multiple districts, my lord. That's the whole issue, my lord. Last time, while passing the order.
At one court, they will have to appear.
Yes, well, it has already been verified and passed this by the Ghaziabad district, my lord. That has already been done.
Directed to be released on bail, subject to the fact that a true surety, along with the necessary bail bonds, shall appear before only one court of Chief Judicial Magistrate.
At Ghaziabad.
Which shall appear.
Districts in total.
Maximum cases are which place?
My lords, their maximum cases actually are in Bagpat and Meerut, my lords. In fact,
Meerut.
Ghaziabad only has
For the Chief
3
Judicial
cases.
Meerut and furnish the fresh bail bonds.
My lord, that will be applicable in all courts, my lord.
This bail bond shall be applicable in all other pending cases.
I'm so grateful, my lord. Just one humble request, my lord. What has happened, my lord, that this order, when the magistrate passes, my lord, it is to be sent to the jail authorities by post, my lord. Whereas the new technology is there, my lord, where e-prison portal is there. So court can easily post that order on e-prison and directly, my lord. That takes weeks altogether. If your lordship may kindly help me out in this, my lord.
I see.
The order can be posted on e-portal, my lord.
Can pass orders, but until and unless the integrated criminal justice system is operational in that district, this order will not be implemented.
No. That's
I will-
e-prison
I will
portal is there, my
inform
lord.
all the districts.
E-prison portal is there where all the orders in which release order has been passed can be posted there, my lord.
But
And
here it is functional.
yes, it's functional, my lord. That's what I'm humbly praying, my lord.
E-portal.
E-portal, my lord. That's all.
Communicated through.
Uploaded. Uploaded, and that can be uploaded on that. That's the whole thing.
No, it is uploaded on our website, it will be.
No.
No,
That from the magistrate.
It's a e-prison portal. Sorry. E-prison portal is centralized portal.
This character you want to, nothing to.
My lord, e-prison portal is centralized portal of the jail, my lord.
You are getting an order where one bond is good enough for entire state.
That's correct, my lord.
Now be happy with that.
I'm so grateful, my lord. I was just humbly
No,
praying.
it's all right. Now nothing more. It's not necessary now.
Lords, I will
Be happy
communicate
with
to the
that.
concerned. I will communicate to the concerned district
So
and to the
so
jail.
that his release order is communicated and given
We are
effect
telling
within
you
24
after
hours.
10 days your application will come that this man's whereabouts are not available. We are aware of this fact. You are facilitating a fraudulent person.
I will not say anything. Grateful.
Please, Your Lordship. Madam, this
Hey,
matter.
आवाज उतारो जो।
There's just one correction, I'm sorry. There were 4 police stations left in which there are a total of 4, not exactly 4 cases, but 4 police stations. So that my lords had dictated
Where verification has not
some
been
cases, I think 7, 8 cases might.
The petition will be released on bail on furnishing personal bond.
I'm great.
Please, Raj. In this matter is related to Alpine Meadows. situated in the state of Uttarakhand, my lord. High Court passed several directions. Out of those directions, we are now challenging only 3 directions, my lord. No one has entered appearance for respondent. However, 8 IAs are filed in which they are supporting our petition, my lord. These are written submissions, my lord. It will clear why we require, because in that area, after every 12 years, a religious procession, namely Rajat Yatra, is being conducted, in which people go on walk for around 280 to 290 kilometers. So one of the main direction on which we want indulgence of your lordship is that High Court said there will be no night stay in these bugyals. These are part of that procession, part of the way. My lord, the night stay is required for administration, for purpose, and for medical facilities, for security staff. It's all these things, my lord. When people walk for 90 days, my lord, kindly see the directions at page 54, my lord.
What is the problem with your?
Pardon, my lord?
Why can't you comply with the direction?
No, my lord, we are complying all these directions except 3 directions, my lord. Kindly see page 54, my lord. Direction A, we are having no difficulty. The state government is directed to remove. No, yes. The state government is directed to remove all permanent structures from the alpine meadows, subalpine meadows, bugyals in the state of Uttarakhand, including Ali Bedni, Bagji Bugyal. This direction was itself modified by the High Court, my lord. Along with my written submissions, I placed that order. This order was modified. Therefore, as on today, this direction is not in existence. So I am leaving this. Direction B, the state government is directed to constitute eco-development committee within 6 weeks in eco-sensitive zones throughout the state of Uttarakhand to protect, preserve the nature and environment and ecology. We are having no difficulty. We are already having this. Direction C, the state government is directed to restrict the number of tourists not more than 200 visiting the alpine meadow, subalpine meadows, bugyals. But there is the difficulty, the number of 200. It is not given whether it is for the entire period, for entire yatra, or for one day. And my lord, number of 200 is very difficult to confine when this Rajat Yatra is processed. Regarding Rajat Yatra, I have given details in my written submissions.
Number 3, what else?
Yes, my lord. Direction D. No person, including state public undertaking, private entrepreneur, shall construct any permanent structure. We have no difficulty. We are not challenging it. Direction E. The overnight stay in the alpine meadows, subalpine meadow, bugyal is banned. That is the most difficult problem. Night stay. Next. F. We are having no difficulty. The commercial grazing of cattle is already banned. All district magistrates throughout the state of Uttarakhand are
That's only where you have difficulty.
Direction L, last direction. The state government is directed to consider declaring all important high altitude valleys and alpine meadows, subalpine meadows, bugyals with rich plant as high altitude national park sanctuaries within a period of 6 months from today. We are already having. Now, regarding this, kindly see my.
Leave granted, hurdle and counsel for the appellant state at a considerable length. In our considered review, directions number C, capital C, E, and L issued by the High Court are impractical, and it is difficult to comply with the directions. So otherwise also, in light of the other comprehensive directions, there is no legal necessity for sustaining these directions. Consequently, the appeal is allowed in part. Direction number C, E, and L, as contained in the impugned judgment of the High Court dated 21st August 2018, are set aside. The rest of the judgment is directed to be given effect in letter and spirit.
Obliged, madam. Deeply obliged.
Lords, pursuant to your lordship's last order, we filed a contempt petition in the Section 9 petition because the respondents, in spite of the injunction, proceeded with the arbitration in Russia. Lords, while that contempt petition is pending, my submission is pendency of those proceedings should not come in way in constituting the arbitral tribunal here. The facts are, my lords, as per the arbitration agreement, arbitral tribunal ought to be constituted in India. We filed a Section 9 petition because the respondents.
Is the respondents notified?
But the respondents of the, my lords, I'm
The
sorry.
Russian,
No, the respondents have not been appearing in these proceedings or the Section 9 proceedings.
The arbitration injunction suit.
That suit is pending, injunction is already granted.
court will not be executed.
Injunction is already granted. Service is complete. In the Russian proceedings, they have taken note of, in the proceedings which are going, notice have been issued, my lords. The respondent is not serving. In spite of knowing of the pendency of these proceedings and the Section 9 order, they have concluded the arbitration in Russia.
No, sir.
Office report, office report.
Probably the jurisdiction.
You ought to.
Office report. Show that register. इसमें लिखा है लॉ मिनिस्ट्री के थ्रू इट इज सर्व्ड.
Do we have jurisdiction in that one?
In fact, the office report also notes, office report of 4th November, law ministry had served them. Yes. Can 28 be? Can I show 28? That's a complete clause. Retyping, there is something incomplete. The clause is that whoever initiates first, I initiated the arbitration first. I'll read the clause. Page number 28, bottom.
You examine it, otherwise we are likely to dismiss this matter.
My lords, I invoked first. Injunction is granted in my favor.
It seems that this clause is quite vague. There is no arbitration clause. You examine it.
My lords, sir, Russia, I'll serve it again, my lords. My lords, may permit me to then serve them on through email.
Item 45.
Your lordship, my lords are permitting me to serve through email, my lords, because
We are adjourning it for 4 weeks. Meanwhile, you.
obliged.
45. Your respondent, I'm for respondent. I'm for respondent, Your Lordship. Your Lordship, as per me, there is no arbitration clause. If you see clause 11.2 of the agreement, Your Lordship, it says, as the exclusive means of initiating adversarial proceedings to resolve any dispute arising under this contract, a party may demand that the dispute be resolved by in the High Court of Delhi.
So what else is required arbitration?
Arbitration.
Lordship?
It is titled as arbitration.
Your Lordship, yes.
Clause is titled as arbitration.
The clause is,
If I may, Lordships, in addition to what your Lordships has pointed out, there's a choice of law clause also in the same arbitration agreement, your Lordships. Therefore, it's valid arbitration agreement. It identifies that arbitration is the exclusive means of resolving any dispute arising out of these agreements, your Lordships. That is my submission, your Lordships.
Your Lordship, and the petitioner and the respondent both are foreigners. Your Lordship, he resides in Germany. And the company to which he has provided the service resides in US. If you see on the bottom of the agreement, Your Lordship, the address of the company is 203 Whitebridge Street, Pittsburgh, PA 15213. And the petitioner lives in Germany.
How does that take away the jurisdiction of the Indian court? When it is said that it will be resolved by the High Court of Delhi, that anchors the arbitration proceeding to Delhi.
But it's a may demand the dispute, Your Lordship. It's not shall, your lordship, it's may on 11.2.
Attention before the arbitrator.
Much obliged.
Allow the arbitrator will appoint some arbitrator. Advocate.
Much obliged.
Both the connected matters also the same.
Both men.
Both.
Please, Your Lordship. Your Lordship, in item number 46, I'm seeking a withdrawal of the petition because there is a settlement has been.
Counsel for the petition, strict and permitted to withdraw the petition. Dismissal of the claim. 47.
Please, Your Lord.
47, Your Lordships, is a matter seeking appointment of arbitrator under section 11, coming up after notice. Your Lordships, pursuant an order of 16th of April, had permitted me to serve them through email. That has been done. The office report says that the service is complete. That email was sent on the 12th of May. The only request that I can make before Your Lordships is that the entire claim is around 30 lakhs. So Your Lordships may appoint a slightly younger.
Serve them.
Sorry, Your Lordship.
Email se serve. Email se serve.
We have been corresponding with the same email ID, and that is found in the arbitral agreement as well.
Where are they located?
Your Lordship, Cyprus, Your Lordship.
Cyprus. Did they reply your section 21 notice?
Yes, Your Lordship. It's on record, Your Lordship.
So that
Page
email address is the same?
Same,
Which you have sent her?
It's found in the arbitral agreement itself.
You sent a notice. Claim is about 25 lakhs?
25 to 30 lakhs, including interest, Your Lordship.
Advocate. From advocate, पिछले केस में छोटे जो amount है. Not for people.
Highly obliged. Grateful to Your Lordship.
Item 48.
Please, Lordship, this is also the petition for appointment of the sole arbitrator. And the notice was issued on 21st of May, 2026. As per the office report, the respondent number 2 and 3 has been served. But with respect to R1, it says that awaited through Ministry of Law. Lordship, we have served them through
We can
e-service and e-filing.
Better we wait for service on this.
Yes.
Lordship, then kindly keep it after 4 weeks, Your Lordship.
For the office, the service on this is still available. This one should do.
Deeply obliged.
My lords, I'm appearing for the petitioner, my lords. My lords, notice was issued on December 17 and service was complete way back on 2nd of January. But till date, no one has entered appearance on behalf of any of the respondents. Please, my lords.
Anyone appearing?
No, my lords, service was completed way back on 2nd of January itself.
All right, then we had said issue notice for remand only.
Yes, my lords. My lords, my only submission is, since my lords are remanding back the matter till the final adjudication of my matter, may I be permitted to continue at my previous job? Because my lord, I am facing a financial crisis, my lord, because I have
Apply
a
to the
family.
High Court, whatever stay you want.
Please, my lords, please. I will definitely mention.
As to why the matter be not remanded to the High Court for fresh adjudication. Next, for the office report, the service is complete. No one has entered appearance on behalf of the state of Odisha or its authority. Can you leave grant for them? It seems to us that the matter requires reconsideration by the High Court by a reasoned order. Consequently, without expressing any opinion on merits, command instance appeal is allowed. The improved judgment of the High Court is satisfied and the matter is remitted to the High Court for fresh adjudication on merits.
My lords, my lords, in 49, my lords may fix some time to for the re-adjudication of the matter.
The High Court is requested to make an endeavor to decide the case within 6 months.
Lord, I appear for the High Court. So Your Lordship had observed that the inquiry proceedings correspond amount are going on. So I've been told now that it's complete. It's just been put up for the approval of the full court. So the final
Lord,
result will
the
come in 3-4
direction-
weeks. So Lordship may just have the matter after 4 weeks if that's what.
Lord, the direction of by the division bench of the High Court is they have to have a review scrutiny committee with effect from 2nd of November 2019, because I was ignored on the ground of uncommunicated ACR, which was subsequently on my representation even upgraded. Then, Lord, the charge sheet is December 2024. As per the law, my Lord, and Janki Raman judgment, they couldn't have done it. The judgment is strictly consistent with the instructions and this Honorable Court judgment.
My Lord, I beg to appear for the High Court. My Lord.
Lord, in fact, since December 25, just hold on, my friend. Since December 25, there are no proceedings before the Honorable Inquiry Judge. It is, my Lord, for the last about 7 months, my Lord, about 600 people have been promoted who are junior to me.
Wait for a couple of weeks. If the disciplinary proceeding amounts to and is dropped, then all consequential benefits will ensue.
Lord may record their statement if it can be done within 2 weeks, 3 weeks.
Lordship
For the High
My Lord, can I just make one submission, my Lord?
Yes,
My Lord, I
Mr.
beg to appear for the
Gautam
High Court. Yes, Lord. My Lord, I just wanted to, my Lord, place before your Lordships, pursuant to your Lordship's order of 27th of April, my Lord,
Yes.
the inquiry report, my Lord, has been placed before Honorable the Chief Justice, who has directed, my Lord, the matter to be placed before the full court. Now, my Lord, it is my instruction that the matter will be taken up by the Honorable Full Court in its next meeting, my Lord. Your Lordships may have it after 4 weeks, my Lord. We'll place the outcome of the consideration, my Lord.
Inquiry proceeding will be concluded.
The inquiry proceeding is over, my Lord.
The inquiry proceeding,
The disciplinary should be
that an inquiry
taken to a
report has
logical
been
law.
submitted, which is lying with the competent authority for appropriate decision. Post the matter after 4 weeks and so on and so forth. Yes.
I say 2 weeks if
Great.
possible, my Lord, because it is already delayed. My Lord. I'm so grateful.
Very great.
Item 52, there is a letter 53.
Mallets in this service is in fact complete for everybody. Only 4 have entered appearance. Bar Council has filed its reply. Others are yet to do. And so far as we are concerned, last time we had indicated that we'll be filing an additional document on the additional policy
UGC.
on the UGC clarification matter. That has been filed.
As far as your prayer D is concerned, that recently there is a Bar Council of India directive which has been circulated. You are
Supreme Court
Mallets, we
explained
need
why.
to-
Now you continue with.
May I request Lordship?
I know very well, I've spent on this side also.
No, it's only request Lordship, have the petition Lordship.
Sorry,
Just look
sorry.
into the fact.
No,
of
sir.
Lordship. That is what I'm requesting Lordship.
Thank
Only
you.
for a week, only
Thank
for
you
a
very
week.
much. Next mention.
Malas, 3 days, Malas, give me 3 days indulgence only. Malas, just me 3 days
Even
indulgence.
if
itself.
completely dismantled today, even then I will not grant it. I should be very clear on it.
Please.
May I please,
That's
Lord.
the only request. Can I have that order out today so that I,
What do we give? You can file it petition.
Malas, I'll ask them to file it right now, Lordship. With the
Because now for regular bail of this person, the last of this. Now I have an
Which
apprehension.
item?
Item 6, my lord. First 5 are early hearing.
ये rings की भी मुझे दिखना है।
It was almost 2.5 years in custody in all. Now, my lord,
Sir, who is opposing?
state of Chhattisgarh.
Led by Mr. Jethmalai.
Oh.
I'm sorry.
Okay.
Lord, I have first a request, my Lord. We are at a very vital stage of our investigation. We have arrested a very vital man. Lord, he's been absconding for 4 years. My Lord, it's a question of attaching 300 to 400 crores. This man had taken 1,000 crores through the present accused in cash. He was concealed and harbored by Chief Minister Baghel at that time in his residence. As your Lordship knows, Chaitanya Baghel, his son, is already one of the principal accused in this case. We need 2 weeks, my Lord, to wind up this investigation. I know your Lordships, my Lord, have an issue. I can deal with that just now on evergreening. on evergreening, your lordships, this new phrase that has come out of evergreening of custody. The others, people who have evergreened their pockets in thousands of scams, going into 5,000 crores of rupees and more. My lord, I now talk about evergreening of custody, but my lord, I can deal with that point that this is not a case of evergreening of custody. This was a distinct, separate FIR. If your lordship want, I can deal with that aspect today and try and convince your lordship.
No, it's a distinct, separate FIR, but that trap
Yes.
was laid in 2023. Information came to you about his involvement in 23.
Yes.
You decide to register the FIR only when he is on the verge of getting bail in other cases.
No,
So
my lord,
if-
that's not
if
correct.
You can take your time in registering an FIR. He is in custody now.
No, we registered this. I'll tell your lordship, but I'll tell your lordship what the procedure is. Let me please, on that point, just try and disabuse your lordships of the prima facie impression you have that this man arrest on that particular day was an issue of evergreening. Now, my lord, we start these investigations on the basis of ECIRs from ED. The ED sends us an ECIR, we investigate, we register an FIR, and my lord, then the rest of the investigation continues till charge sheet is filed. Now, my lord, we got this, we've had about 7 ECIRs from ED. Now, I'll show your lordship about the FIR in this matter. Prior to this, there have been 6 major scams, each of them. One was finally taken off after we investigated the year with the CBI.
Mr. Jetmalan, we should not be understood to mean
Yes.
that we are deciding on his innocence. First.
No.
We are not deciding on his innocence. Secondly, we also understand the ramifications, the seriousness,
Yes.
and the high personalities involved in this crime.
Yes.
The fact remains that there is a series of FIRs where he was repeatedly arrested.
Yes.
The trigger of this FIR starts in November 2023, when someone was carrying cash to another person who is a part of the racket in distribution, and his involvement transpires.
Yes.
FIR gets registered.
Yes.
He is not arrested in that case. And now after 2 years, he has been arrested.
Now,
he was in custody, available to the investigating agency, being in custody in other cases.
Yes. May I answer your lordship?
Situation.
I will not answer that.
Create a sense of punitive detention.
I agree, but not prima facie.
Draw a line, sir.
Subject to what I have to say in reply. Now, my lord, this ECIR. Give me the ECIR. Give me the FIR first. Give me the ECIR. Where the FIR? Take out the pages. No, you've got to have the pages. 17. Where is the FIR in your SLP? Please take out the pages.
373.
One and a half years? If 1.5 years. FIR is इसमें तो FIR में 28 लाख रुपए की FIR इसको 110 बना दिया. These are doing everything in liquor. This is not liquor. This is a subset of liquor in which I got bail. In which I.
Yes, I know this.
Lord,
No, yeah, I've got the facts. Now, Lord.
Lord, with great respect.
Party in custody.
That one is not.
Your lordship is right. I didn't want to say that, my lord, but
This is another attempt of evergreening. My lord, I have got bail. Every time I get bail, new case, bail, new case. Your lordships have granted me bail. 2.5 years I have spent. This will go on like this.
If within next 2 weeks, if they register another FIR against you, we can assure you we will grant bail in that.
No, there will be no. We are at the fire again. This is the last charge sheet.
No, again.
No. I'm making a statement that this is our final charge sheet. We are almost winding up our investigation.
I don't think that should be granted.
We are in
I beg your pardon.
Final charge sheet is being ready.
We have 4 charge sheets. 4 supplementary charges. So five supplementary charges. So this is the last one. And that's in the liquor scam. Yeah.
Your Lordship may grant bail today, my lord. He can be released after 10 days. They can do that also. Every time it comes before your
Well, just subject to hearing me next time. 2 weeks. Next time, just hear me.
Again, you are saying subject to hearing.
No,
This is
next
not,
time, hearing.
can't go on like this.
You already heard.
Yes.
No, but I'm not, my lord, in this matter, my lord, please, next time, please don't.
You are supposed
but
to be
because
fair
this is not a
as a
case of
prosecutor.
Just hear me on that aspect.
And shall in all circumstances be completely within 2 weeks. And say, post the matter on, today is 20th.
It is 20th. Today is 20th.
3rd August.
3rd August. I'm obliged.
May it please, my lord. Item 7 is a case of fixed match. Fixed to the core.
If the state chooses not to arrest, can a person be denied anticipation?
Then he has no apprehension of arrest, my lord. If the state is choosing, I could understand this, the High Court holding, my lords. Every
You can dismiss it. You dismiss it.
They want to start first, perhaps. Yes, my lord. May it please. Now, please see from page 6, paras 8 on.
What is your locus standi?
I have challenged it specifically. I asked for impleadment. That is the other matter that is listed before your lordship, my lords, in 57. Now, in a case, my lords, where the state and the accused, I have a list of all the accused persons who were not granted anticipatory bail and were granted regular bail, including by your lordships, where the state opposed tooth and nail. And from page 6 onwards, my lords, there are observations.
What is your, if somebody has been granted bail,
Yes.
what is your problem?
It's granted bail is okay in a circumstance, but not in a case where it's a fixed match between the state and the accused, my lords. Kindly consider this. In a case where
Dictate the court that in what
I'm not
circumstances you should grant the bail and.
I cannot dictate, my lords. I'm before your lordships. I'm beseeching your lordships. I went to the High Court. I said, hear me. High Court says I will not hear you.
Why, I could rightly say.
But
who are
my
you
lords,
to-
if somebody is granted bail, my lords, illegally in a
Had
manner.
you been, in a case where suppose a victim of crime wants to be heard, victim has a right to be heard.
There is no
You are a
victim.
stranger.
The state is the victim here, my lords.
You are intermeddler.
We kindly consider in large scale corruption cases where the state says large scale 3,500 crores, etc. is the corruption case that is there. Now suddenly it turns benevolent towards one accused person who they have not arrested. High Court finding is contradictory in nature. High Court says you can't rely upon.
If you will be in power, then you will.
That's the whole. I'm not.
The party will allege corruption.
But there has to be a limit, my lords, as far as anticipatory bail is concerned. Kindly
It will be embedded with power.
My lords,
So that's why when you were in power, they were alleging. Now they are in power, you are alleging.
Let's kindly consider legally, I'm saying, legally kindly consider if a person wants.
Legally, we will consider suppose state comes. We
The
will
state is
consider-
hand in glove, my lords. If the
Victim
state
will come.
My lords,
We will
kindly see
consider.
the state says in the High Court that no, we don't want him. He's the only one out of all the accused persons, my lords, whom the state doesn't want. And even now they filed a caveat and sitting by the side of the accused person saying that yes, this order should be maintained. Because what could be more gross in a 3,500 crore corruption case, which the state is tom-tomming from day one when other bails were coming.
The relief is different. Relief is different. You are saying it's a biased investigation, trying to cover up one accused in favor of another, a pick and choose of accused, right?
Yes, my lords, that
For
one.
that, your right is not to seek cancellation. It may be something other.
For the
There
reason.
may be some other relief which is available of transfer of investigation, etc.
If it was a
But yes,
investigation ending over
transfer
to
may-
some other.
Lords, if it was a,
But not
I bow down just,
lovely, but
there is a difference, my lords. If it was a case which was considered on merits.
we can justify the stance of the prosecution also. There are cases and cases, and it's up to the investigating agents and the prosecution to decide in what manner they will conduct investigation and prosecution
Yes.
to ensure a conviction of more important accused persons.
Then I'm obliged to your
than others.
lordships.
In
Then
this situation, if the prosecution chooses to loosen its grip on one, we as judges cannot.
true, my lords. But
prosecution.
then that foul of 306 immediately, because it can't be used, my lords, with respect. Now your lordships knows the law. I don't have to explain the law to your lordships, my lords. If it is done with the ulterior object that I will take pardon, I should be released in bail on anticipatory, then that pardon, the entire process is vitiated.
That is where a co-accused will make out a case. That this is a very weak piece of evidence.
This is the co-accused.
This is a public interest
Other.
Mr. Dave, you know very well, trial court will see that what is the evidence.
No, my lords, it can't.
Credentials and credibility of the evidence of a co-accused who has been pardoned.
The trial judge, my lords, in this case, when it dismisses the anticipatory bail, holds that the purity of the administration has to be maintained. Otherwise, what will happen tomorrow, my lords? Out of 5 accused, 1 person will go and sit in with the public prosecutor and kindly consider, my lords.
To challenge the order of granting anticipatory bail to his number 3. His application for imprisonment in anticipatory bail proceedings was rightly dismissed by the High Court.
However, if there is change in circumstances,
But, my lords, tomorrow if he doesn't speak the truth, what are we supposed to do? Suppose he does not speak the truth.
Making it,
It will
giving a rider,
the state or
just listen to me.
state or any or the investigating agency from seeking cancellation of bail, keeping in view the change in circumstances.
If there is any change in circumstances.
That's why, my lords, the provision says that you should continue being in jail for this reason, which
But then we have clarified that law. That law was more a very oppressive colonial restriction.
yes, my lord.
Because it was why that restriction is to protect the witness protection principle,
Yes, my lord.
not a accused
I bow down.
detention principle.
I bow down.
So if there are adequate safeguard and protection of the witness otherwise, just to deny liberty may be a too aggressive, disproportionate.
But they should have considered in 2024 when they overhauled the laws. I thought overhaul was meant that the colonial hangover should not be there.
Should have been, should have been.
Should have been. But they has asked, my lords, even one criminal lawyer on the side of across the country, I'm not saying me, one criminal lawyer, at least 30 suggestions we can make today to make the overhaul of BNSS working much better, my lord. 30 suggestions on the fingertips, my lord. But if you retain all the old
social service.
Sir, you are absolutely correct that we can make further improvements on BNSS.
Yes, my lord.
There is no doubt about that.
There is
That
no
is
point.
that it was a very positive step of
Yes.
moving out from the code of.
But
Right, trial in absentia was really necessary.
That is required.
Really
Absolutely.
necessary.
It is required. Because there
Bangladesh
is-
had an amendment. This court gave directions.
Yes. Because I'm only praying the co-accused has also challenged this order. This may not come in his way, my lords, that he's passed.
He will see his locus.
Yes, because this is on locus that your lordships are denying this relief for locus.
You on locus, when he will come, we will ask him also to show you locus.
Yes, my lords. All right, my lords, ask him.
Listed today, no?
No, that's not implicit. I'm only saying because it will come before your lordships, my lords, for that reason. Grateful, my lords.
Item 8.
My lord, in this, the primary concern is that the PM Kisan Samman Nidhi shall be.
Can't you go to,
And representation were also given, my lord, but he was not heard.
why can't you go to your High Court, sir? Tell us.
My lord, this is the central government scheme
Ah,
and implementable to the entire nation.
High Court has no jurisdiction.
High Court has jurisdiction, but it is implemented for the entire
Or
farm.
your status and standard of the petitioner does not permit him to go to High Court. That is the whole problem.
We are not saying that there is no jurisdiction, but the scheme is implemented throughout the nation for all the farmers.
No, we are not saying jurisdiction. Sometimes the petitioner feel that my status and stature is so high that I can't go before a High Court
He is a poor,
unless there is a higher court.
no, my lord, he is a poor farmer and already he gave representation to the central government, but he was not issue any notice.
To High Court, the jurisdictional High Court, they will summon the record, they will find out everything and determine.
My lord may
No case
pass
to entertain this
directions on the
petition.
representation, my lord, that he may be heard.
No case to entertain this petition under Article 32 Constitution made out. The petitioner should advise my approach to jurisdictional High Court.
And my lord, additionally, he may file another representation on which he may be.
Thank you very much, thank you.
Great.
Item 9.
I'm seeking a passover, my lords. Item 9, passover.
Also.
Only passover.
His foot is.
Please, my
First.
Your lordships, in item 10, we are being led by learned attorney general. He's in court number 2 right now.
Worship, I request for a passover.
Sorry?
Yeah.
I'm so sorry.
My lords had given a direction, if my lords will see.
Your lordships, we are being led by learned attorney general. He's in court number 2 right now. If it can be passed.
Not towards Chandigarh unit.
Yes.
We have transferred her to
But not
Zirakpur.
the headquarter.
We have transferred her to Zirakpur, your lordships.
My lords, they
been
physically
already
transferred her, didn't shift her headquarter. Consequently, in Chandigarh, they give her a single accommodation, no
that's what
attendant. Her
Chandigarh-
husband can't be there. No,
No, where have you posted?
Zirakpur, she is posted right.
not the
There
headquarter.
is a posh complaint now made. So it is in the fitness of things that she should be under the control of some other officer.
They've been transferred.
So explained that if she has been transferred to Jirakpur, then why you are keeping her attached with Ambala?
So your lordship, the commanding officers for both Zirakpur and Ambala cantonment are same actually.
So why can't we, the commanding officer in Chandigarh then?
There's no canton, there's no. Everything will have to start again.
You are also making unnecessarily inviting orders from us.
What about the residents also?
She is
Complaint as it is.
She has been given residence a proper family accommodation at
Has been
Zirakpur right
given
now.
only a
And it was
transit
done way back in last week.
accommodation. Transit accommodation. Only a transit accommodation, no attendant
Learned
in her
DPs.
mental condition, and no, otherwise, and her position, she's entitled to a vehicle, not even given her the vehicle. And my lords, even when the doctor advised her rest, complete rest, she is being forced to join. In fact, she tried self-harm. In this whole process, she tried to even
1 year since this order.
I find a one-sided version sometimes is, I would like to, I don't think I will buy this one-sided version so easily. I've looked into the document. I'll put in a small reply. I satisfy myself that all those allegations are not as true as they want the project. And then I don't want to say anything beyond that at the point of time.
This is how sometimes they are.
She has been posted at Chandigarh.
They,
Your lordship says she will be posted at Chandigarh. She has been posted at Chandigarh. Chandigarh means.
they are also, you see, this is what, now they are before me and I know about the area.
Your lordship says.
Frankly speaking, they are absolutely, the entire effort is to violate our order.
No, I'll put in a,
This kind of
I'll put
conduct.
in a reply and tell your lordship, probably the allegations are not.
The headquarters of the British.
Water will be shifted from Ambala to Chandigarh. Jaipur is a suburban area of Chandigarh.
There are two places where she could have been posted. One near opposite Panchkula, the other is Zirakpur. She has been posted at Zirakpur. You did not say which area should be posted.
Mr. Advise them to do the needful by tomorrow or day after. Otherwise, we will take a very serious view.
No, before your lordship take the serious view, let me also say something like this. Your lordship only said instead of Ambala to Chandigarh.
We said headquarter will be shifted from Ambala to Chandigarh. Now
Correct.
what they have done is they have posted her Jirakpur, headquarter is kept from Ambala.
No, that's not correct. There's nothing like that. Inquiry will be held in Chandigarh.
Tell
There's
them
no
to
question of
post-
Ambala figuring the picture at all.
Tell them to post her by tomorrow to Chandigarh.
She's already posted in Chandigarh.
No.
She is posted in Chandigarh. She is saying Zirakpur. Zirakpur is part of Chandigarh. She is going to PGMIR every day. She is taking treatment there. She is no longer in Ambala.
Mr. Attorney, then you are right. She is posted at Jiratpur, but her headquarters continue to be Ambala.
No, the inquiry will be held in
They are not on
Zirakpur. There
inquiry,
is no
they
question.
are on headquarters. The
The
orders
question-
are.
Your Lordship, be correct. When the order, your Lordship passes order,
See.
the
how
question
the
of
order-
inquiry will not be conducted in Ambala because
Now she shall be shifted her headquarters from Ambala to Chandigarh.
she
The
is,
simple thing is her posting at Jiratpur does not shift.
but
her
the inquiry
headquarters.
is also in Chandigarh. There's nothing happening in Ambala.
Sir, we are not. on
And she has
inquiry.
been
We are
repeatedly asked to come
compliance
for
of the
inquiry.
order.
I'll put the reply, your Lordship will find,
Inquiry in Chandigarh.
with great respect.
What prevents them from posting her to Chandigarh?
There are two places where she could have been posted. Zirakpur is one commanding officer, other is Panchkula.
Please, learned
Your Lordship
attorney,
knows,
we have used the word Chandigarh in our order.
Chandigarh means,
Why they are digging out Jirakpur?
no, Zirakpur is part of the Chandigarh.
I know, no, Jirakpur is not part of Chandigarh, I know, but.
As far as the army
Jirakpur is
headquarters,
of Chandigarh.
as far as the army is concerned, there are two places where she could have been posted. One is Zirakpur, other is opposite Panchkula. So Zirakpur happens to be the place where inquiry is being conducted.
Please advise them to faithfully comply with the order, we are posting it day after.
Kindly allow me to make a few more submissions. Lord, just give me a few more time. I'll file the reply, but what's happening is, there are about 15 officers who have been made as respondents. None of them have anything to do with what she's talking about. None of them have nothing to do with it. A Secretary of Defense is being in a contempt now. She has nothing to do with all that.
Mr. Attorney.
And for after she been posted as Zirakpur,
In the department is supposed to aware of the court order and ensure compliance. It is their duty to see.
I'll show all that complaint, but what is disturbing is, for more than 9 months, she's been asked to come for inquiry. She goes to the hospital, but would not come for inquiry.
Mr. Attorney.
She goes to the hospital regularly.
Disciplinary inquiry, if you find her guilty of misconduct, dismiss her.
No,
But we are on a limited issue where we have given a direction of shifting headquarters. If the headquarters is not shifted, but is transferred to Chandigarh, then it's not a clear compliance of our.
That's a misconception, I think.
That's the limited
I clear the misconception.
We understand it.
What is being done, being posted,
Vexatious and not a very reliable
At the
officer
cost of
as per your
repetition.
standards. That is
therefore,
what
the
we
cost of
expected.
repetition, I would like to say, Ambala has no more anything to do with the inquiry or a posting. That's the whole story. Ambala has ceased to exist as far as inquiry is concerned.
What simple, and that cannot
only
be
a-
as
that's
per
only
our
a-
order.
That could be only a paper order, but as far as your lots are concerned, please post it at Chandigarh because she did not want to have an inquiry at Ambala. She's been posted at Chandigarh.
Compliance of that order. So it can be attached to Chandigarh and also the inquiry can continue. She's anyway treating.
Inquiry is also happening only in Chandigarh.
Vijay Chandigarh also, she's taking treatment and her accommodation also has not been provided as per the order.
No, even the commanding officer has been changed. So many things to ensure the inquiry is has been done.
Then I can come back and file an affidavit, but then.
Do that,
like,
but I
by
want to say
tomorrow,
this
day after.
is a maybe sympathy cannot.
To issue a very simpliciter transfer order, posting her to Chandigarh under the commander at Chandigarh and shifting her headquarters to Chandigarh. That's all.
There is, your lordships knows, in Chandigarh proper, there is no military establishment. Chandigarh means.
We are communicating very clearly. If they will indulge in still any effort.
No. I'll satisfy lordships because before I can answer anything, I have satisfied myself that there is nothing wrong that happened. But although everyone says Chandigarh does not by itself have any military headquarters, but there are two places. One is Zirakpur, other is opposite Panchkula. So Zirakpur is the place where she is staying. She is staying there, attending the hospital. So there is no other way one could have done that.
Headquarter. If she's not attached to Chandigarh headquarter, it's only a temporary position out there.
No.
She doesn't get the attending facilities which she needs in her present condition. She is
So
a
for the past 9 months, she would not come for inquiry.
Lieutenant Colonel.
She is avoiding an inquiry. She goes to the High Court.
Attached to a head.
She goes to the High Court, argues the matter herself.
She, my lords, that's.
She
not
goes
correct. I just want to show something, the way this
Very
is going on.
unfortunate.
I didn't want to show that, but my learned senior will please look at page 96 and it speaks.
Nothing.
for
We have,
the conduct.
I am convinced that we have not done anything which is wrong.
Shown that, sir. Please look at 96. She was in a hospital. The medical officer records that she's
Because the
supposed to
matter on
sign
coming
documents.
Friday, the respondents are well advised to comply with the order in its letter and spirit and submit a compliance report. Friday will take.
Please, my lords, I'm so obliged.
You not kindly have it on Monday if possible.
All right,
Or
next
Friday.
Monday. Item 11.
Your lordship.
Monday, next Monday, lordship, can accommodate next Monday, Friday.
We don't require you, just decide. We will exempt all of you. Mondays they have some difficulty.
Yes, sir.
Friday she's telling.
Let it be at a convenience. I have no problem.
My lords, I have no Friday.
First she wants.
Very well. Whatever.
She wants 31st.
You have no time. But
Very good.
whatever it's convenient. Ready?
Your lordship, in this matter, the High Court itself has acted as a court of appeal and reversed the findings of its.
And you are becoming now super appeal while coming to.
Your lordship, they have gone against the findings of the full court, your lordship.
Hello, he granted statutory bail 167 to default bail. Had he not granted, this court would have taken him to the task.
Your lordship.
And you are charge sitting him, dismissing him. Poor fellow died.
Dismissal of a judicial officer because he gave statutory bail. And High Court takes that effort to bring it to Supreme Court.
Your lordship, because it is against the decision of the honorable full court, that's the only.
That is why we are saying that the honorable full court should have more knowledge in cases to pursue. Is this a case to pursue?
Man also died. There's no.
Absolutely. On judicial side, being perfectly in accordance with law. We see no ground to interfere with the influence given dated 3rd November 2025. That's why the division bench, especially petition dismissed.
Your lordship, there was delay also in filing it. Okay.
May it please this honorable court, I appear on behalf of the petitioners in this matter. Well, not here the concern. Well, Lord, in this petition, my lord, it is the concern that children are being mandatorily asked to register under a non-statutory scheme. So the first objection is this court has pronounced that all such data collecting schemes require a law. The reason being they violate the right to privacy under Article 21, and therefore you need a statute. So the first submission is there is no statute in place. It has been introduced under circulars of the Ministry of Education. That, my lord, is the very first objection. My lord, the problem here is that it is not in compliance with the Data Protection Act. I understand.
It is purely a voluntary scheme.
My lord, unfortunately.
As it appears to be for the benefit of the students.
Yes.
For the benefit of the young students.
Yes.
So that their relevant information with respect to their school, their subject,
yes,
their performance.
Yes, their credits.
Credit, this remains at one place.
Yes.
So that when you go from A school to B school,
Yes.
everything can be transferred immediately.
Yes, my lord, the classical problem of issuing transfer certificates is
Because
facilitated.
otherwise, Madam Indra, there are instances where a child, because let us say one example, where parents are transferred from
Yes.
A place to B, and you shift the child also A to B.
Yes, my lord.
It takes months and months in getting the record of the school transfer.
Yes, my lord.
Now with this form, it will simultaneously.
I understand, my lord. I understand the argument that there is a legitimate aim. However, the preconditions for that have to exist. Number one, there has to be a statute under which you frame this scheme and say,
Statute will be required. You are right. Statute will be required if you impose a mandatory condition.
no, my lord, with great respect, a statutory scheme is required whenever the right to privacy is threatened. So what is my argument here? My argument here is that this scheme, which they have put in place through a circular, which is, your lordship will find that circular, just come to that circular, it will become very clear. It's at page 84. 84. Now, my lord, the real problem arises in a twofold manner. It has become mandatory for children to have an Aadhaar card in order to be included in the list of candidates who are sent up for class 10 and class 12. So if you see the circular at 27/8/2025, the date is 27/8/2025, it's annexure 16. Please come to the last paragraph, Upper in Indian schools. CBSE has earlier widely circular dated so-and-so, already communicated to schools regarding implementation of APAR ID as the primary identifier. Please make a note, a lot of primary identifier for students of CBSE affiliated schools only in India. Hence, schools associated with CBSE in India will be able to fill the LOC. LOC here stands for list of candidates for who have the APAR ID. The APAR ID filled will be validated by the board at the time of submission of the LOC. Therefore, my lord, what is this saying? This is saying that your name will not be included in the list of candidates unless you have indicated your APAR ID. And now one more thing, in order to create an APAR ID, you mandatorily need an Aadhaar card. Now, my lord, here my argument is that in Puttaswamy of 2019, this court held that children do not have to have an APAR card. So, my lord, the way the scheme has been visualized, first every child has to have an APAR card, then every child, first every child.
Will not have, parents will have an Aadhaar card.
Not parents, children also. Children also, because this court said that the right to education is a fundamental right. It cannot be burdened.
That's right.
Therefore, it cannot be burdened with a need for an Aadhaar card. You're not giving a benefit. You're allowing students to pursue an education. I'll point to that paragraph, my lord. Now here, what are they saying? Now to create an APAR, my lord, I see the point which is being put to me, that it may be for the benefit of the student, that it facilitates a transfer certificate all over the country. However, it does require the mandatory existence of an Aadhaar and an APAR, because an APAR cannot be issued without an Aadhaar. So, my lord, this becomes a three-stage mandatory process, though on paper they call it voluntarily. First, you must have an Aadhaar, then you must link your APAR card with the Aadhaar. Only then you become eligible for your name being included in the list of candidates. Now, my lord, whatever be the legitimate aim, perhaps your lordship is right in putting to me that there can be a legitimate aim for something like this. The doctrine of proportionality also comes in. The doctrine of the right to be forgotten also comes in. These are documents which are put in a digilocker and maintained throughout the life of me. I begin as a child, my lord. I might have failed, I might have passed, that is my lookout. After that, my lord, I might have got distinctions, I might have got scholarships.
You see,
all that. So therefore, my lord, what?
Let us not doubt everything in this country with a suspicious eye.
My lord, give me a minute.
It's a very welcome
My lord,
step.
I understand. My lord, give me a minute.
I am not doubting it. A legitimate aim. That's why I said you might have a legitimate aim. But your lordship also will look at whether that legitimate aim has been achieved through a proportionate means, the least restrictive of all means. That is one question. And secondly, my lord, we have a Data Protection Act in this country. May I point attention to that act? And my submission is that there is non-compliance with the Data Protection Act. So, my lord, the relief that I'm asking for can be, my lord, either a striking down, in the alternative, my lord, safeguards being put in place on the issue of consent. Your lordship put it to me that this is a voluntary scheme. How voluntary is voluntary? Now, my lord, I want to point attention to the Data Protection Act, which tells you how consent is to be obtained. Please start from section 5 onwards. My lord, there is a procedure prescribed by law for obtaining consent. And my lord, I'm given to understand all these safeguards are there, my lord. The right to be forgotten, the right to remove the data from the locker if you don't want it there. After it has served its purpose, it cannot be maintained there for life. It cannot stay there forever. The consent can be withdrawn. It has to be informed consent. So therefore, my lord, you need to put in place certain checks and balances which will ensure that consent when given, and by the way, my lord, these are children. So the consent is not given by the child, it's given by the guardian. So the consent which is given, my lord, has to be informed consent. If your lordship will just turn to the Data Protection Act for a minute. Where is it? It is a High Court judgment. Have you got copies for them? You want me to show section 6? The Data Protection Act. You want them to read section 6? You want me to point out section 6? Yes, I'm doing it as soon as they give me an opportunity. My lord,
data protection, etc.
Yes.
We have already a law in the country. That law is applicable to everywhere. They can't violate that law. Nobody can violate that law.
My lord, there's one, I have, just let me read one section and then I have a suggestion to make.
What it appears to us, that's why we are saying, the entire idea is basic purpose is that throughout the country, in the CBSE headquarters, you are sitting here, you know that in which school or in which region, how many students are studying science, how many students are studying bioscience, how many students are studying social studies, political science, because it will help you in maintaining the teacher-pupil ratio also.
Yes.
And it also give you an idea that how many teachers are required to be recruited in which subject. Otherwise, what will happen, Madam Indra, that you appoint 1,000 teachers in English subject. Suddenly you find requirement is only 500. You recruit 800 teachers in science. You require 1,800 are required. So it is only for the purpose of smooth implementation of the education system curriculum. As far as the data protection is concerned, you are right. Suppose if the circular says so and so act will not apply.
No, I understand, my lord. I understand. If I may just, the two things to which I would like to draw your attention. One is section 6. So, my lord, perhaps the way out would be, I do not doubt the need for macro level data, my lord. That is, as your lordship put it to me, helps in policy formulation. Let's assume, my lord, for a moment that is correct, that macro level data, there are 240 million students in the country today who are going up for these examinations, my lord. We will assume for a moment, as has been put to me, that this data is necessary in order to decide policies for education, how many teachers to recruit in which subjects, etc. We leave it there for the moment. We are concerned with the micro level data. I'm not concerned with the macro level data, my lord. It is the micro level data. It is my right to be forgotten, my right to withdraw my consent, my lord. And this is where the Data Protection Act comes into. I don't want people to know when I'm being recruited or when I'm in my career in my 50s and 60s that I possibly failed in a particular examination when I was 15 years old.
That is exactly what DPDP Act protects your right.
Yes.
And DPDP Act is not excluded
No, my lord.
from the DG locker,
Yes, my
which
lord.
is maintained by CBSE.
Yes,
That
my lord.
is to say, CBSE has no right. In fact, it would be a violation of law if CBSE shares this data with a third party without your consent.
Exactly.
As
Exactly.
you rightly said,
Exactly.
consent has various layers.
Yes.
It's a layered consent of storing data for CBSE's personal use or institutional use. It can't be used for any other purpose but for the fact for which the data has been shared.
Yes, my lord.
Your question issues,
My lord, that purpose limitation, yes,
really get answered by DPDP Act.
that purpose limitation is not at all clear. My lord, if I may just draw attention to Section 6 of the Data Protection Act. Lord, may I have a suggestion to make. I have a suggestion to make, my lord, if it appeals to you.
Issue was answered in the Aadhaar judgment.
Yes.
Where they said that you had this balance between privacy and right to development. As you see, here is a balance of right to education and privacy. And it said that when you make the proportional balancing test, the sharing of Aadhaar for the purpose of targeted delivery of services and goods is proportionate, but it can't be used for any other purpose but for the above purpose.
Yes.
And in this situation, CBSE is bound only for the institutional purpose to use your data and nothing else.
My lord, with great respect, my lord, it is clarified undoubtedly in the judgment. However, the judgment goes a step further. The judgment also says we are dealing here with children. And the right to education is not a targeted service. This is a further step that the judgment takes. If you're giving some definite services which are beyond what you're given under the Constitution, it's a different issue altogether. Here, what we are saying is the right to education is given by the Constitution of India. No further service is being asked for from the state. Therefore, asking a child that you must have a mandatory Aadhaar and mandatorily have an APAR in order to be sent up for your examination for 10th and 12th, my lord, to that extent. Now, my lord, I have a suggestion to make which might meet the ends of justice if it appeals to you. My lord, this matter was in fact carried to the Orissa High Court as well. And there is a judgment of the High Court, which if I may just, if you have copies, just give it. Otherwise, I'll read it. Para 16 is just one paragraph which might appeal to you. A careful reading of the different clauses of the consent form, that is the form which they issue. Not para 16. So the problem is really with the consent form, my lord. My lord, your lordships are right. The controversy may lie within a narrow compass, and the narrow compass could be this, that there is a problem with the way in which consent is being obtained. So, my lord, the Orissa High Court, this is what they had to say, para 18. If my lord could just have glance at it, paragraph 18.
Ms. Jason, the LOC has always been there. It's only the methodology is slightly tweaked to include other also, I mean, the APAR also if necessary, if they are willing to do that, that's all. The whole circular is about LOC, which has always been there since many years. For 10th and 12th, we also did that. Everybody did it.
Your ladyship, it's not been there for 10 years. It came under a circular of 2025, which is not available in the public domain. Let me make that also clear. It is only in 2026, that circular 25, 27/8/25, that this circular came. And one more thing, my lord, they were themselves not able to comply with this circular, so they have temporarily suspended it. If you see at page 125, their own infrastructure for implementation was not ready. Turn to page 125 and you will see over there, they have made a temporary suspension of this. Considering the time-bound nature of the activities relating to submission of LOC for class 9 and class 12, the schools are directed to take the following action.
Going to lack of consent also, so they don't mind. It's not mandatory at all.
No. That's my argument is not that on paper, in law, they say it is not mandatory. The question is, how does it get implemented on the ground? I just want to focus on that for 1 minute. And all I'm asking for is to make the implementation procedure consonant with the non-mandatory nature of the law. And therefore, my lord, this Orissa High Court judgment might be of some use to us. If I may read it, a careful reading of the different clauses of the consent form revealed that there is no option to refuse consent at the initial stage. Nothing has been placed on record as the consequences that would entail upon refusal of a parent to submit the consent form. The withdrawal of consent as per the last paragraph of the consent form cannot be treated as giving an effective right to the parent to protect the privacy because at such time, the consent would already have been given. What the petitioners are concerned with is the right to refuse. Exactly what has been put to me, that is not mandatory. Consent altogether at the outset, since the right to privacy is a fundamental right, and though not absolute, can only be subject to reasonable restrictions, the same has to be protected and respected by the state at all costs. As already stated above, the principles have been acknowledged in Puttaswamy. And then, my lord, the final order. Thus, from a conspectus of the analysis made here and above, this court finds that the petitioners have made out a good case for interference by this court. Resultantly, the writ petition is allowed. The opposite party authorities are directed to consider what, Lord, is not a striking down. Consider amendment to the model consent form to indicate an opt-out refusal of consent option therein. The model consent form incorporating such changes as provided by the learned counsel for the petitioners to the learned DGGI may also be considered. Necessary orders in this regard shall be passed within 2 months. In other words, my lord, a time limit was granted to them to reformulate the consent form. Now, my lord, my simple request to this honorable court is this really should have all India application. This particular direction of the court, namely you reconsider how you're drafting your consent form, put in the necessary safeguards, and at this stage, I will only read Section 6 of the Data Protection Act. Basically, the provisions of Section 6 of the Data Protection Act should be incorporated within the consent form. Lord, if I may just point out to Section 6. Lord, everybody is not aware of the implications of what they're signing. These are what are known as fixed term contracts. All of us sign these consent. Lord, we are signing all the time.
1 minute. This judgment is under challenge?
To the best of my knowledge, it is not under challenge. To the best of my knowledge, I cannot make a definitive statement.
CBSE is a respondent here?
Yes.
So they
I believe they are
automatically-
on caveat, my lord.
If they are a respondent,
Yes.
and if the judgment is attained finality, then they have to.
Already accepted.
That's the reason I'm here before you, because we are concerned not just with the state of Orissa, we are concerned with the whole country, 240 million students.
Judgment is not restricted to Orissa.
My lord, it is necessary for the Supreme Court of India to give a definitive opinion on what is consent. As I said, my lord, we are all the time giving consent. These are fixed term contracts. They're like fixed term contracts. Your insurance policy, what do? You click. Your app, what do? You click.
Here was a case where factually they had a form, they had a difficulty, they went to the High Court. High Court has said it's incorrect.
It exists. I can
UPSC
show
is
you.
bound.
I can show you, your ladyship, I can show you what the schools are doing. I can show you what private schools are doing also. Give me the school letter.
72.
Page?
72.
72 and 82. Please see 2 pages. Every school, Holy Agnel School, as per CBSE circular dated 27th August 2025, we are required to validate students' APAR ID for LOC 10 and 12. For the creation of an ID, we need your Aadhaar card of the student. Without Aadhaar card, APAR cannot be created. Where is the communication that you have a right not to consent. Where is it? And then you look at the next one at 82. At 82. Every school is issuing this circular. Well, Lord, please see page 82I also. Lord, kindly see page 82.
All right, if we say that the clarification or the modifications directed by the High Court to be carried out will be applied on pan-India basis. That takes care.
Well, Lord, one more, if your Lordship can just look at page 82 for a moment. Well, some direction will also have to be issued to all schools. Look at the kind of letters they're issuing. 70, I showed you, see 82. Kindly note that the Controller of Examination, CBSE, has mandated the creation of a unique 12-digit identifier as automated permanent academic account registry.
Interpreting letter.
Yes,
Be an
but
individual grievance.
They are wrongly
Blanket.
interpreting. They are wrongly interpreting.
That's why if we clarify this now, probably with that, any parent who is aggrieved or any school's directive like that can approach it.
Lord, I think it's
Can't presuppose
your Lordship
situation
decide
where the
what
entire
is the way
India's
forward.
are going to ask.
I can only make two suggestions. One is what has been put to me by way of a clarification, which will apply across the board. And the other is, my Lord, your Lordship does know about 5 or 6 petitions challenging the Data Protection Act are already filed in this honorable court. If your Lordship so pleases, this petition may be tagged along with those petitions. We need not get any interim order today. But my Lord, when your Lordships are looking at the Data Protection Act, because I am claiming right under the Data Protection Act, Section 6.
I think data protection petitions are altogether different. This will unnecessarily, because this is something, entire scheme is beneficial for the students.
No, my Lord, what I'm suggesting is the provisions of Section 6. I'll just read it for a moment and then leave it to you to decide what is the best way forward. All I want is the provisions of Section 6 of the Data Protection Act to be applicable to these schemes also. And of course, my Lord, my argument, your Lordship will take on board that there is no law. Perhaps they will pass a law in the future. That's for them to check. My Lord, Section 6, just read Section 6. The consent given by the data principle shall be free, specific, informed, unconditional, and unambiguous with a clear affirmative action and shall specify an agreement to the processing of her personal data for the specific purpose and to be limited to such personal data as is necessary for such specified purpose. And 8. Also 8. Now these, if your Lordships is good enough to clarify this, general obligations of data fiduciaries. A data fiduciary shall, irrespective of any agreement to the contrary or failure of the data principle to carry out the duties provided under the Act, be responsible complying with such provisions of the Act and the rules made thereunder in respect of which any proceedings are undertaken. So, my Lord, if your Lordship so pleases, this mandate of Section 6 should be part of no, I have nothing more to say except to say that these rights guaranteed under Section 6 must find a place in the forms, in a direction issued to the CBSE that this has to be followed. At an all India basis, we're talking about 240 million students over here. And some may definitely want it, some may not want it. As I said, my Lord, it's a lifelong record. And it can have very, very adverse consequences. It can be used for purposes for which it is not intended. I understand using it for formulation of policy, but it can also be used for surveillance and for profiling. There's no doubt about that. So, my lord, whatever your lordship feels is the best way forward in guaranteeing the rights to privacy, that too, my lord, without definitely your lordships have seen there's no law in place. The scheme, as I told you, only evidence of the scheme is at 16, at a petition, annexure 16. That's it. Nothing else. There's no law. There's no amendment to the statute.
The petitioners themselves are students or whom?
Yes, my lord, the parents. This petition is brought by parents. Yes, yes.
Class 2, class 4 and class 10.
Yes, my lord, they're parents.
I think all of them.
So what we are doing, Madam Indra, that one we will direct the CBSE to give effect to this judgment on pan-India basis because they have accepted this judgment. And if there is no challenge that they have to comply with, it can't be confined to Odisha. On the other issue which you have raised, we are directing the CBSE to examine those issues and if need be to suitably clarify their policy.
Very well. Your lordship may just draw their attention to Section 6 of the Data Protection Act because it does require strict compliance. And it also requires strict compliance with all the schools that are issuing these kind of circulars saying this is mandatory. Very well, Blanc. I just did want to mention, I think CBSE is on caveat.
Yeah, they did file caveat.
My lord, I just wanted to mention for your information, CBSE is already on caveat before you. Whether they appear or not is not my lookout, but they are on caveat already. CBSE applies now.
My lords, item 13. Sorry. My lords, item 13. Yes, my lords. My lords, on a lighter note, my lords have taken my counsel to the other side.
My sister had argued that case. In fact, probably my sister is responsible for generation of this litigation today.
No, sir, the Union of India in this case and argue it here.
List before a bench here, my sister Mona is not.
Wait, please. Not here, the High Court has granted permission for cutting of 75 mangroves. Now the project is construction of a 2-lane bridge over a creek, which is part of a larger coastal highway. Our contention is whether you look at 2011.
Also in this country needed.
Yes, whether you look at the 2011 CRZ or the 2019 CRZ, it's not permissible. This issue is already engaging your lordship's attention in a batch of matters. The lead matter, my lord, I placed the order at 162. A similar question arises. Whole bunch of
There is nothing like similar question arising.
No,
no.
I'll explain this one.
You argue, please, what is the point there?
Yes, Manoj. So now the question is, they are saying that give us permission to cut 75 mangroves for building this project as part of the coastal highway. Now permission is granted under 2011 CRZ. Now whether we look at 2011 or 19, I'll just show the provisions. According to us, it is inapplicable. Your lordship may have the 2011 CRZ and kindly may not come to page 52, which is part of the 2011 CRZ, where the classification is made. Here we are dealing with mangroves. Mangroves are classified under the 2011 CRZ as CRZ1 zone. That your lordship will find at page 52. May I just read, my lord?
7A.
CRZ, Manoj, classification of CRZ at the top of 52, para 7. For the purpose of conserving and protecting the coastal areas and marine waters, the CRZ area shall be classified as follows. Then CRZ 1A, areas that are ecologically sensitive and the geomorphological features which play a role in maintaining the integrity of the coast. The very first is mangroves. In case mangrove area is more than 1,000 square meters, a buffer of 50 meters among the mangroves shall be provided. Now, this is mangroves. Now, your lordship may see what is the list of permissible activities that your lordship will find at page 53, para 8. They have given as per the definition of which CRZ, what is permitted and what is not. Para 8.1, CRZ1, which is at the foot of page 53, no new construction shall be permitted in CRZ except project relating to Department of Atomic Energy, pipeline conveying system, etc., facilities that are essential for activities under CRZ1, installation of weather radar, so on and so forth. This kind of project is not there. Road is mentioned in the second para at page 54, part 2, which says areas between low tide line and high tide line which are not ecologically sensitive. Necessary safety measures will be incorporated while permitting the following, namely, and B, construction of dispensaries, schools, public rain shelter, community toilet, bridges, roads, jetties, etc. So road comes in areas which are not ecologically sensitive, but mangroves are defined as ecologically sensitive. So under the 2011 CRZ, where permission has been granted, the project is not permissible. That is our contention. Now, I have a further contention on similar lines that actually the 2019 CRZ was applicable. I won't not waste time
Your
putting that.
contention is that everything should come to standstill.
No,
Nothing
not
should
at
go
all.
in this country.
But then what is the purpose of the notification? There are two, three other issues.
Buses and car, they should.
No.
Why don't you come to para 8 of the High Court judgment where this very argument is dealt with?
No, I'll just read that also. Para 8 is at page 9.
Please read.
Yes, upon the MCZMA being approached, it is noted that 4.09 hectares mangrove land shall be affected due to the project, and the project proponent will be required to take all the possible measures to have a lesser footprint in the mangrove area, and compensatory mangrove plantation should be carried out in consultation with the mangrove cell. It stipulated a condition that prior High Court permission should be obtained as per the High Court order dated 79/2018 and PIL 87 of 2006. May I just pause here for a minute and explain this? This is a seminal judgment passed by the Bombay High Court.
That's right. That's why High Court is granting. Please read further.
Yes, that's very well. The MCZMA noted that as per para 8.1 of CRZ, construction of road on stilt and bridge is a permissible activity, and therefore after due deliberation, the MCZMA decided to recommend the proposal. No, this is incorrect. 8.1, mangroves are defined as ecologically sensitive. Road and jetties permitted in area which is not ecologically sensitive. The finding is incorrect. This is one. I raised other objections also that compensatory afforestation is being given 240 kilometers away. The whole purpose of providing that compensatory afforestation cover gets defeated. Third objection I raised was this entire project is 498 kilometers. Project proponent is coming for clearance for only 115.
Para 11. The problem is that every year you want to become the super specialist.
No, we are the Bombay Environment Action Group. That PIL was our petition.
Para 11C.
Yes, Manoj. Para 11 on that page. I'll read that. The proposal forwarded by the MSRDC, which is the project proponent, was scrutinized, and even the project site was inspected by the DFO, Mangrove Division, Kunkan. The site inspection report was also forwarded to the Revenue and Forest Department. The detailed report had a mention of flora and fauna as the project involves diversion of land. The DFO mangrove cell certified that the mangrove forest area proposed for diversion is less than 1 hectare as per the guidelines issued by MOEFCC under the Van Sanrakshan Evam Samvidhan Adhiniyam 1980. The plantation of 10 trees shall be done. No, that is okay. That is certainly there. But where is the plantation being done? That was my objection. Please see. That will be done as 75 trees were to be felled by way of compensatory afforestation on the degraded mangrove forest area, land survey number so and so. No, this is degraded forest land which is 240 kilometers away from the project affected site. Now, two issues arise here. One is under these very rules of 1980, which are mentioned here, the 2023 rules framed under the 1980 Act.